late, so we'll get back into traces here. Take a minute or two, but we're all glad you're here and looking forward to a productive day. So the secretary will call the roll.
Senator Selby Galton.
Here.
Senator Hicks.
I don't know anything, so we'll just assume he's on his way.
Senator Kensky. Senator another comment.
She's in parking lot. She's ready.
Representative Biden.
Here.
Representative Jennings.
Here.
Representative Olson.
Here.
Representative Pelka.
I'm here.
Representative Brown.
There.
Representative Salazar. Here. Representative Stiff.
Here.
Representative Winters.
He was there. Parking lot.
Chairman Christensen. Chairman McBride.
Circling the airport, and here for Kurt Fry. Thank you, Brian. We have before us the minutes from the May meeting. They were emailed to you. They're also sitting in front of you on your desk. Anyone have any additions or corrections to the minutes? I'll make a motion. Move to approve by Pelkey.
Second.
Second by Panel. All in favor say aye.
Aye.
Opposed say no. Approve the meeting minutes from the May meeting. Tori Recidivism, our staff attorney, has some introductions and some housekeeping materials for us. Tori.
Thank you, Mr. Chairman. Again, my name is Tori Recidivism. I'm one of the staff attorneys for this committee. Most of you know Brian Fuller is seated next to me. He's done yeoman's work on getting this committee ready. Two people I need to introduce that you're not familiar with. Seated next to Brian is Sherry Briggs. She joined our office in August. She's a legislative editor. She's here to help out in Mary Beth Oaksfall's absence, who's our normal legislative editor. However, Sherry will be primarily assigned to the bill processing unit, so she'll be working closely with Debbie Child. She came to us from the Attorney General's office, where she was a long time paralegal with the criminal division. Sitting next to her is Kayla Spencer. She joined LSO in August. Kayla is a staff attorney. She will not be assigned to Judiciary, at least immediately. However, she's here to learn our processes and observe, and also to help out anyway. Kayla came, graduated from UW Law School. She clerked for Judge Cranfield in Park County, and worked in private practice here in Laramie at Forthell and King before joining our office. A couple of housekeeping matters. We are live streaming. Yes, over there in the corner, they've got a camera. So you're on the internet being live streamed. We are also audio recording as usual. And just a note, the legislature this last session, as you know, passed an amendment to 28.8.116. During these meetings that are being live streamed and audio recorded, anything that's captured on the live stream or audio recording is not confidential. So be aware of that. You have microphones before you. They are all off. They are kind of lapel system microphones. There's a button on the top that you push to the left or right to turn on and off. So when you are speaking, please turn it on and be aware to turn it off when you don't want to be recorded. These are courtesy of UW. We've got 6 legislative committee meetings this week. So all our normal speaker systems and microphones are currently in Thermopolis and Buffalo, I believe. Same thing for your paper nameplates. They're spread out around the state. So with that, the only other issue with the lapel microphones, if you see that your battery is running low, they apparently do take the batteries quickly. We have extras here, and just let us know and we'll replace that. Thank you, Mr. Chair.
Okay, thank you, Tori. It's our custom to introduce elected officials and judiciary members who are with us, and I want to take a moment to do that. We have Judge Martin Tyler and Judge Timothy Davis, 92 District. Appreciate having you here. We have Sheriff David O'Malley and County Attorney Peggy Trent. Marc, please. Oh, okay, and we have Judge Vanessa Steinfeld as well. So thank you for being here. Appreciate your input. I was thinking as I we walked around last time on campus and over this morning, and surrounded by 20-year-olds and 25-year-olds and young people I was encountering, that as a good reminder to meet at the university every now and then, that's really what we're about. We're not making laws and decisions and having deliberations for people like me. We're making them for all the people over in married student housing, trying to lay a good foundation for their life in the state. I've been in the library for many years, and I was thinking it was the scene of many an ill-used hour of the 70s. Today we'll try to make good use of it. We don't have any breaks built into the agenda. I'll try to give you about a 10-minute break in the middle of the morning. So don't have to get too desperate, but we'll try to hold it down to just the 10 minutes because we got a lot of things to do. So, Mr. Co-Chairman, welcome. Good morning. Any comments from you?
Got a couple of senators that are on their way, so check that. Like we're here to see y'all and look forward to a nice 2-day meeting.
So, the first thing on the agenda, we're going to be discussing the Justice Reinvestment Program and Marc, who's been our guest before and has been working hard over the summer to prepare this materials for today is here. Marc, will turn over to you.
Thank you, Chairman Kirkbride, and thank you, Senator Christensen, and thank you, members of the committee. It is a real pleasure to be back in front of you, and we're grateful for the really strong turnout and for members of the public, and policymakers, officials, criminal justice system professionals. You'll see some slides coming up regarding our activities in the previous several months, and the highlight for me is getting a chance to travel around Wyoming. I live out east, and I began to think that maybe it'd be time to set up residency in Wyoming, because I fall in love with your state, and I think come tax season, I live in New York, it might be really advantageous. And so maybe you have a new resident or versioning resident on your hands here. So the last kind of big gathering we had was back on June 11th for the statewide forum on public safety. And the question is, from June 11th until today, we fanned out across the state to have different meetings. We analyzed a whole lot of data. And what we pulled together today is a distillation of the key findings from that analysis we've done, data and a qualitative input from people who know the system far better than we could ever imagine. And this presentation in front of you is probably the longest presentation. I recognize quantity does not equal quality. The quality I'll talk about in a second, but this is probably the longest presentation we put together, and it's a reflection of the amount of time that the Joint Judiciary Committee has dedicated to this issue. And it was that knowledge that you were dedicating this time to really hearing from the results of our analysis that we dug in real deep. And it's divided across several sections of the presentation that we hope will be a helpful kind of roadmap for strategies to increase public safety and avoid cost in Wyoming. Along with the PowerPoint slides here, we also have a kind of key to the content of the presentation that all members, and we also have here at the table, covers the key analysis for each section, as well as the initial policy options that we list. And finally, we prepared a glossary of key terms, recognizing we're going to get into the weeds. And for those who would like to refer to a glossary, you'll see some of the terms that we use or the various acronyms that we use. I'm afraid some of you in the audience will be facing difficult direction to see the slide transition, so we'll do our best to kind of know that we're transitioning slides, and I hope the PowerPoint in front of you will be helpful for kind of following along. There are no page numbers in the PowerPoint. The slide numbers are listed at the bottom of every page, so if you just want to mention slide numbers with a question or a reference, we'd be more than happy to refer to it. I'll be doing a fair amount of the presentation today. Some ways will be the MC, other ways will be the presenter. But we brought a staff who've been on site at various times the last several months here in Wyoming, who will be coming up to co-present at various points, and I'm really eager for you to hear from them. These are the names of the folks who worked on this presentation all along the way. Raquel, who's sitting closest to the door, you definitely met her during the June 11th State Forum on Public Safety. We found ourselves at Walmart picking up toothbrushes and other things we forgot, and we were cruising the University of Wyoming section, and Raquel, she didn't buy already, was eyeing a sweatshirt, so I think we have some Wyoming promotion we'll be doing back where we're from. Grace, who's sitting to Raquel's left, is a national expert in victim service delivery and trauma, and she's got engaged in the project as well, and will be actually presenting at the section later this morning. Seated closer to the screen is Jennifer Kisela, who is a national expert in the area of community corrections, probation parole supervision, recidivism reduction strategies. She works extensively in states that are implementing justice reinvestment policies as well. And she, like I, have worked in many of the surrounding states. Currently, she's working intensively in Montana. We also overlapped in Nebraska, and she's going to be appearing this afternoon in the sections regarding supervision outcomes. To my immediate left is Ed Weckerly, who is our research manager in the research of this project. He is quite humble, so what I'm about to say is going to embarrass him extraordinarily, but he worked so hard in this presentation, and I love working with him. We worked together in Idaho, Nebraska, Pennsylvania, and other states, so working with him was a delight because he not only can delve into data, and you'll be seeing, spoiler alert, he collected and analyzed 1.2 million individual case records from across the system. And that's a feat in itself, but what I think you'll enjoy most is that he's able to visualize and present it. So the PowerPoint relies very heavily on charts and graphs and tables, which we hope will be a productive way or useful way to review the slides. I'm going to begin turning through the presentation now, and I'll certainly pause at the end of every section. I'm going to cover, just get ahead of the slides. I have the presentation overview on slide 14. I'm going to begin first with the here earlier. You'll see it on page number 2, backside number 4. That's the 6 sections to a presentation. So I'll begin with the overview and introduction, and then I'll get into the topic of achieving improved recidivism reduction among people with nonviolent offenses. A lot of information regarding the front end of your system, arrests, court filings, prison admissions, and I'll be joined by Grace for section 3, which is looking at the topic of connecting crime victims to compensation, assistance, and restitution services. We are thrilled to be joined at that section by Kara Chambers, who directs the Division of Victim Services in the Attorney General's office. She's phenomenal, and it's a pleasure to work with her and learn from her. In the afternoon, there are 3 sections left. The first concerns delivering adequate supervision and programming to people who have the highest risks and needs of recidivism. Then using supervision, incentives, and sanctions to promote positive behavior change. So heavy emphasis in the afternoon on probation and parole. Very important because probation and parole revocations are driving prison admissions. We did a kind of analysis digging into the sources of some of those trends and strategies for Wyoming to focus its resources on where it had the biggest impact on recidivism reduction. Finally, overcoming barriers for people in the criminal justice system who have behavioral health needs. We're thrilled to see staff from the Department of Health here today, as well as both directors and staff from Wyoming's community mental health and substance use centers. And we also, we're excited to have delved into behavioral health issues in the institutions, in the community, and we're eager to bring some information back to you today in the presentation. Mr. Chairman, Chairman Christensen and Chairman Kirkbride, before I get going, are there any questions or any help before I delve into the overview introduction?
No, I'm good.
Okay. Thank you, sir.
Please continue.
Thank you, sir. Again, we all work at the Council of State Governments, the Council of State Governments Justice Center, nonpartisan nonprofit membership association. Last weekend was the CSG West, the Western Office's annual meeting. A number of members of the Joint Judiciary Committee attended that national meeting to share information across state line, across branches of government, across a party. And Wyoming will be actually hosting in 2020 the annual meetings in the state. So it's exciting to see Wyoming be promoted through CSG. And so there are a host of different areas within CSG. Justice Center is the one we all work for. And Justice Reinvestment, which is what Wyoming is using for approach, is the most intensive, penetrating, deep dive into a state's criminal justice system issues. We leverage the expertise across our organization to assist states. So there are centers within CSG on youth, on mental health, on law enforcement, sports. And so you'll see the input from that analysis streaming into what we provide to you today. We hope you'll use resources on our website or from our organization, however you would like. Now we'll turn to the beginning of the introduction and overview. Justice Reinvestment is a data-driven approach that states use, tailored to their particular challenges and goals for increasing public safety. We've assisted 29 states using justice reinvestment approaches. There are other organizations assisting states, but what we really emphasize is the fact that states can use this approach however it chooses to, whatever the issues are that it wants to address. And we will help through that process on a phase 1 and a phase 2 to slide 6. We are right now probably about a little past the halfway point of phase 1, intensive analysis, presentation to a bipartisan working group, engagement of stakeholders in the system, development of policy options. We're kind of at the point now where you'll hear from us on initial policy concepts. We recognize you have one more meeting to go. We wanted to speak first about some areas for policy development, sort of our conceptual ideas about our concepts for how policy could be developed to address the challenges that you'll be hearing about. And I mentioned Jen's expertise in implementing justice reinvestment approaches. That's what's called phase 2, which is eligible to all states that have completed phase 1. So imagine if the policies were become legislation and are ultimately signed into law, assistance is available, funded by the Department of Justice, federal level, to implement the policies. And it helps, I think, to have that phase 2 presence for a program-wide basis, because you can be involved in the state where the rubber really hits the road. The policy designs and the analysis leading to the policy options that are actually being implemented. And so that is assistance that would be available to Wyoming if there was actual policy to implement. I mentioned the 29 states that on slide 7 have used justice reinvestment approaches. Currently, along with Wyoming, Ohio, Oregon are using phase 1 of justice reinvestment, and Missouri is in the process of implementing. Grace worked intensively on Missouri's justice reinvestment approach. So they're all different stages. The blue have completed, the yellow are in the implementation phases, and orange are live, like you in phase 1 of justice reinvestment. The next couple slides will cover kind of a recap of where we're here, what brought us here, and where we are in the process. The beginning of Justice Reinvestment officially was in Moreland in May for the first Joint Judiciary Committee meeting. The next big event was a statewide forum on public safety 1 month later. And then you can see, as you can see in this table here, from July to August until today, we've had interim updates to the Joint Judiciary Committee while doing site visits around Wyoming. And then after today, we expect we'll be guided toward additional stakeholder meetings regarding policy options and further analysis, so that we're back in front of you, members of the committee, in mid-November, November 15 and 16, to review some options for policy development in the form of a bill draft. And our funding to assist Wyoming continues through the legislative session. So when the committee's work is complete, if we can still be of assistance to the state, we remain engaged with further analysis, reporting, engagement with stakeholders, however we can assist. So we are thrilled to have that ability to continue at the request of your state leaders working here in the state. And for anyone who is without a packet, there are still presentations available. You feel free to raise your hand. I think Grace would be more than happy to run you over a copy of the presentation, or feel free. Sorry, Grace, I hate assigning you.
I felt fine.
Terrific.
Each reader, hand out the handouts.
Thank you, Grace. We captured a picture, actually it comes from the Wildfire report of the State Form of Public Safety. We've got to add a footnote, but that was a picture that was taken. We really got to capture the focus and attention on the statewide issues. Over 100 people from across Wyoming came to Cheyenne to the day-long state forum on public safety. There are roughly 18 state forums happening across the country in all different states, various ones of us help in different states. Over 100 was on the high end of turnout. A day long was on the high end of time-wise. And the governor was able to attend, Governor Meade, but he submitted a video statement and press release in which he really acknowledged that everyone in that room, wherever you're from, victim services, behavioral health treatment delivery, probation, parole, Department of Corrections, law enforcement, on, judges, on, defense, prosecutors, you are there to help in that process of public safety. Look at how Wyoming responds to mental illness, substance abuse, and violent crime to keep our streets and our families safe. We use that state forum to really hear from people across Wyoming in one setting so that we could direct our analysis, meaning Ed's leadership on the analysis. And so we collected and analyzed over 1.2 million individual case records, and they came wherever we could find them across our system. We typically use statewide existing databases. The time that we have, it is really hard to run around your counties collecting individual data and trying to piece it together. I'd like to really appreciate and applaud the Director Lampert, Deputy Director Steve Lindly, Marc Harris, Department of Corrections, for all the data that they pulled together. It was a rich data set that enabled us to look at admissions to prison, releases, snapshots, program assignments, risk and needs across the board. Appreciate the Supreme Court providing us with some case filing information so we could look at the front end. We use the Division of Criminal Investigation, Director Woodson's shop, the Crime in Wyoming reports to delve into the reported crime and arrest. And we have a pending request putting together with the Department of Health that is really groundbreaking relative to other states we've worked in. We are looking to match probation and parole data with people who receive the service in any of Wyoming's contract mental health and community mental health and substance abuse services centers. That's an ability to bridge that gap between health and corrections to look at some issues involving people on probation and parole who are accessing those services. You'll see an allusion to that analysis today, and we expect between now and November to come back with some detailed analysis thanks to DOC and Department of Health's work to connect us with that information. And these are the examples of the places that we've been to on slide 11 around Wyoming. We list in blue the sites that we visited. Raquel and our expert in behavioral health, David Mora, are heading to Jackson to present to the Wyoming Mental Health and the WAMSAC fall meeting. And while they're there, they'll meet with some folks around Teton County. But these trips that we made, we are grateful for the stakeholders who opened the doors to us. I really enjoyed the chance to work with so many people in the room on this. I got to know Byron Odikoven very well from the Wyoming Chiefs of Sheriff's Association. He actually was planning my visits to jails in the northeastern part of the state while recovering from a broken ankle suffered on the Bighorn horse ride he gave. And to see his presence in Campbell County and other jails around was fascinating. And I learned a lot about patrol, custody, issues involving sheriffs. We visited all the adult community correction centers in Gillette, Casper, and Cheyenne. I see several directors here. We're grateful for you to let us observe programming in action and see the people who are in the centers. We observed parole board hearings. My coworker drove to Riverton to observe 3 of your board members doing parole hearings. We appreciate the staff for making that possible. We also observed probation parole officers in action with their caseloads. We learned a lot, and Jen's going to be covering that in her section. So we tried to cover, wherever we were, structured visits like those you see on the right side of the slide, while interacting with stakeholders in the criminal justice system however we could during those visits. What brought, I think, and really kind of set off this process is on page 12, which is a desire by state leaders in Wyoming to understand what factors are driving this line chart, which reflects the growth in Wyoming's prison population. Between 2008 and 2018, it grew 21%. And currently the prisons are at full capacity. And to relieve pressure on the system, the DOC has contracted with private contract facilities in Mississippi, in-house, in-state jails, and also as using inmates as ACCs to relieve that pressure. So it's full, and it's also projected to grow by 9% over the next 5 years. That's based on a simulation the DOC does of projected growth based on historical recidivism, historical trends, in-time snapshots, and length of stay estimates. So cerebral pressure in the last 10 years, 200 bed projected increase, and there are no rooms at the inn. And what we try to put forward to that is the estimated cost to accommodate that growth. It would cost $51 million over 5 years in Wyoming to contract to accommodate that increase and to construct beds to accommodate that growth. The contracts essentially would get you through 5 years, but it's hard to imagine after that 5 years being able to rely on that much capacity. So we had a construction estimate as well, $51 million. And in some ways, those costs have begun. I reflected those with the number of beds in the previous page, but it's $2 million a year to house the inmates in Mississippi, about $1 to $2 million a year for in-state contracts, and $16 million in proposed new construction in Torrington.
Mr. Chairman, I have a quick question. Representative Pelka, thank you. You note a 21% increase in prison population. Is there a commensurate increase in crime rates, or are we, it was my impression that it's actually, okay.
Yes, sir. Mr. Chairman, Representative Pelka, the crime is down overall in Wyoming from 2006 to 2016, according to FBI UCR reports, the data they collect. Very slight uptick from 14 to 16, but overall it's down, and driven by a significant drop in your property crime. So there is no connection we can make between reported crime and the prison population. What you'll be seeing in the next section is ways that you can trace particular arrests for drugs and some of the trends in case filings and prison admissions. But to answer the representative's question, there's no correlation between overall crime trends and your prison population. And that's members of the committee and those in the audience what we're eager to delve into next. This is going to be our first dive into intensive analysis, looking at the how to improve recidivism reduction among people with nonviolent offenses. And Representative Pelka's question really teed it up nicely. For each section, we'll begin with a section overview of what's to come. This is not going to be covered already, it's foreshadowing. Drug offense arrests, case filings, and prison admissions increased significantly in Wyoming, straining both justice system responses and behavioral health community treatment delivery. Some violent offenses, arrests, case filings, and prison admissions, such as aggravated assaults, also increased. Connecting people with substance addiction needs to treatment and supervision would help law enforcement shift its resources more to violent crime reduction strategies. Our interviews with law enforcement executives stress the need to connect people with substance addictions, as well as mental health and co-occurring needs, with community treatment and supervision to lower recidivism. People sentenced to probation have lower recidivism rates than people sentenced to prison, regardless of risk level. Wyoming-specific analysis you'll see later. And substance addiction treatment in the community is shown to have a much higher impact on recidivism than treatment delivered behind the walls. So let's delve into some of those analyses that led us to those overview analyses. This is, as Representative Pelka was inquiring about, the reported crime in Wyoming all the way from 1960 to 2016. And for virtually all those years, your reported crime has been lower than the U.S. U.S. rate. The 14th lowest property crime rate, the 11th lowest violent crime rate. Your property crime rate has dropped by half since 1990. Violent crime rate now 19% since 1990. This is what stood out to us back in May when we first presented to you, is in the last 2006 to 2016, an increase in drug arrests, 42%. This is a catch-all category, including all types of drugs and also all types of drug behavior, possession, manufacture, and trafficking. But it gives you a sense of law enforcement arrest activity and what is being driven to respond to. And drug-related offenses constitute 16%, almost 1 in 5 of all arrests in 2016. And so that gives you a sense that there are people getting involved in the justice system for drug-related activities, so very front-end indicator. What's interesting is that overall, your total arrests per slide 18 are down 13%. In more recent captures, it's 2013 to 17, here we use your DCI data. Total arrests are down, the drug possession arrests increased. So if you look at those 3 shades of area at the bottom, we tease those out into the what we call high volume tier arrests, and you can see the drug possession jumped 26%. over that, those 5 years of data. And everything else decreased within that high volume. So here we're not ranking severity or seriousness, we're just showing tiering these based on volume to give you an idea of law enforcement arrest activity. Going down one tier below, you can see that arrests for many offenses also are down, but some stand out. Those include an increase in aggravated assault, 15%, and an increase in drug possession, drug manufacturing and delivery of 59%. So again, another category of drug that went up. And in the time period, as well as the aggravated assault, which is concentrated more in the 16 to 17 year period on the aggravated assault, whereas the drug manufacturing delivery, that's been felt for much of these 5 years of data that we have available. And then finally, the last tier, these are the lower volume tiers, but they include several of the serious crimes. They represent a small fraction in volume of total arrests, but they are probably the more complex cases that are being responded to by law enforcement. But this gives you a sense sort of the volume breakout of what is driving arrest activity in drug possession, manufacturing, and trafficking all connect to the big volume view we had starting out.
Mr. Chairman, Mr. Chairman.
Representative Winters.
Thank you, Mr. Chairman. May I ask a question? Yes, sir. I just wanted to know just how large, in the state of Wyoming, we're of course a low populated state, what size we're talking about, how many cases we're looking at, and can 1 or 2 cases really drive the data massively as in comparison to other states?
Great question, Representative, and through the chairs, you can see drug possession comprises about just probably about 3,750 arrests around 1,000 arrests in 2017. That's on your higher end volume. So movement in that area has potential shifting trends. Yet not enough overall because your total arrests are down despite that 26% increase. So I would say that total arrests remaining down by 13% over the time period, a single arrest cannot shift that. It can prevent you from dropping lower, and it can affect, especially, you'll be seeing a county-wide map of, county-specific map of trends in drug case filings. And that might give you a sense based on the relative size of your population counties, how they might be felt by that, what effect that might have. That might be a good way of looking at it, Representative. But in terms of these volumes, you can see there's such a large composition total, and each of these can play a part, but it's hard to imagine one offense swinging it, although some have more effect than others.
Mr. Chairman,
Senator Nethercutt.
Were you able to identify the type of drugs involved in the increase in the arrests?
To the chairs and the senator, no, we could not, because that data does not. I think that would require it. That's relating to the way it's reported to the state and also to the feds. To get at that would require conversations with individual law enforcement agencies, police departments, or sheriff's departments, which we did, not in a representative sample way, but we talked to them to hear what were the types of drugs, what were the impacts of those arrests and taking into custody people with drug-related offenses, so we kind of learned about it, heard from it. I don't think it'll satisfy you with a data response to it. I can say that every jail I visited and interacted with sheriffs, deputies, and staff, the top 3 priority for them relating to behavioral health in the community. I heard many times that jails can do a really great job of holding people, of managing them, no matter where they're coming from into the jail, stabilize them, but they count on what happens after he returns to the community after the sentence, after the variety of factors. So that's how we try to meld quantitative and qualitative to get a picture.
Please continue.
Thank you, sir. The shifting now, here we go to the case filings. And again, it's an interesting question I think that Representative Winters was getting at is, how can court case filings be down by 3% overall, yet you have a 19% increase in felony case filings? I think that is part of what you'll see throughout this presentation. Some of the challenges to that question is that relying only on aggregate without trying to tease out what's going on below it can mask actual trends. So you can be showing decrease overall in arrests, yet you can still have an increase in aggravated assaults arrests, drug arrests. Here, you can see your misdemeanors, which comprise a much larger share, probably about 85% or so of your total case filings, Misdemeanors dropping by 6% contributed significantly to the drop in overall case filings, yet you do have an increase in felony case filings of 19%. The limitation we have is we don't know what happened after that case was filed in court. What we can show based on what we have available is case being filed inside of a court. Could have been let down, could have been dismissed, could have been actually led to a conviction and disposition. But we do know that about 500 people arrive at prison every year on a new court commitment, and about 2,800 people are given probation terms. Half of those for felony, half of those for misdemeanor. So we have a bit of a black box after case filing, but this is giving you a sense that courts are also seeing some challenges. And here we break out by every offense comprising a case filing on the left side felony and the right side misdemeanor. Drug possession between 2013 and 2017 doubled on the felony side. Manufacturing and delivery of drugs went up by 61%. Aggravated assault by 12%. And on the misdemeanor side, we note the 41% increase just over the 2013 to 2017 period. So, when we lacking, I guess, a parsing of the drug data to know what types of drugs were part of this or anything more about specifics about the case, what this shows you is you have a volume of cases involving drugs entering into your system that are going to be managed in a variety of ways based on the type of offense, the type of drug, by criminal justice, by behavioral health. And that's sort of the preface to the story that you'll be seeing, I think, throughout the presentation when you look at probation and parole supervision, probation and parole violations, and how sanctions are used in your behavioral health. Ed did a great job on depicting these are the trends in slide 23, the change in the volume of drug-related criminal case filings. And you can see this trend is covered 2013, 2017, and it covers both volume and percent change. Interestingly, this depiction showed us that 4 counties under southern tier experienced substantial increases, both in percent change in drug-related criminal case filings. And those are some high populous counties that we're talking about there, which can drive the numbers in terms of location. You also will see, for example, Weston County, which is one of the smaller, less populous counties in your state, experienced a volume change of 75 increase, led to a percent change in Weston of 268%. So based on what your foundation is and where your trend is, if the number isn't competitive with a Laramie or Natrona County, the percent change in that county can be considerable as courts look for effective options, appropriate responses for individuals who might be experiencing behavioral health needs, or could be coming from the court for other reasons. And also, I would note that there are many people who are probably receiving case filings for property offenses or other offenses that would have an assessed behavioral health needs. So by saying drug offense, we are in no way suggesting that this population is apples to apples, a behavioral health need population. It just means that you're more likely to find higher risk and higher needs within this population. And this is showing on slide 24 who's coming in the front door of your prisons. This is our ability to show one admission stream from those previous slides you saw. Over half of Wyoming's prison admissions for new court commitments in the most recent year, 2017, involved nonviolent offenses, property, drug, DUI. The drug offense increased by a small percentage.
Mr. Chairman.
Senator Kinsley.
Hey, Mr. Pelka, pardon me if you've already done so, could you define new court commitment for me? Thank you.
Mr. Chairman and Senator Kinski, the new court commitment involves a person who received a sentence from a court to one of Wyoming's prisons, a new conviction. They were not on probation or parole at the time of arrest. They didn't get revoked sentence, a brand new court commitment. And those are people who you don't have any current supervision of, essentially. They may have a prior criminal history, they probably do. They may or may not have been in prison, but at the time they were sentenced, they were under no criminal justice supervision. The drug offense increased by 3%, driven by a 46% increase in possession. Again, a reminder of the importance of unmasking the aggregate trends to look at what might be happening under the surface, and also the assaults drove an increase in violent offense admissions to prison over that time period. So if you look at the top line there, where does that wave of numbers crest? It's really at 500 or so, down slightly from that, but about 500 when we expand this population to include probation violations, look what happens. It jumps on slide 25 to over 800. So the reason why there's a lot of content in here on probation for a variety of reasons, but here is one, that the number of the trends in drug offense admissions jumped to 19%. You include people who are on probation along with those who receive a new court commitment. And that increase in drug reduction was 75%. So adding a probation violator really points to the opportunity you have to change behavior, hold accountable, and more recidivism among that population.
Representative Winters.
Thank you, Mr. Chairman. Also, I noticed this on a slide about 5 or 6 previously as well, but I note 2 things. First of all, there's a massive rise in violent offense. Do we have any statistics on how many of those were related to drugs specifically? Also, of course, the increase in drugs. Second thing, also noticed the massive downturn in DUI offenses. Do you have anything that shows why that has dropped?
The chairs to Representative Winters, those are great questions, and the way that we calculate categories is each category reflects the most serious offensive conviction. So if you were convicted both of a drug offense and a aggravated assault offense, we would list as a violent offense. So that's just a way that we code and organize the offenses with the most serious offense, most serious instant offense. In talking to members of law enforcement here and elsewhere, they know that drug behavior often motivates the types of offenses, mainly frequently on property crime, in terms of the efforts to commit offenses that would lead to embezzlement or burglary or theft and things of that nature. So it's again an interesting way to parse both the offense and then the behavior that might be behind it. You raise a great point about DUI admissions, and anecdotally I've learned in visiting 2 of the jails, Natrona and Campbell, the former has a 24/7 program. Campbell's looking to launch it soon, and the sheriffs were very excited to get that off the ground. I don't have a chance to have gotten into the sentencing side of things. That was an interesting observation, but I did notice that the DUI downturn actually traces back to your arrests. So there was a drop in DUI arrests of 18% between 2013 and 17. So you may be seeing a drop in maybe a reflection of behavior, maybe a reflection of the changes in laws, maybe a change in education, enforcement. In any event, you can trace back the DUI drop to the arrests, which is where they began.
Representative.
Thank you, Mr. Chairman. So I guess the question is, do we see a corresponding drop in the use of alcohol as drugs begin an increase, or does your evidence show anything in that relationship?
Chairs and Representative Winters, there are annual surveys that are conducted across the United States involving alcohol and drug use, as well as mental health issues. I do not know offhand what those trends show for Wyoming. I'd be more than happy to find it because it's a useful way of looking at a point in time as well as trends, and perhaps others who are here working that field might have some information. But that's how I would get back to you. So I thought it was interesting to show the combine both the new court commitments plus the probation violators, and to look at the issue of what that cost is for the people who are winding up. And again, we trace them back to the front end of your system. We estimate that it costs $23 billion every year to incarcerate someone with a property, drug, or DUI offensive conviction. They stay in prison for about 22 months. The average monthly cost of prison bed is about $3,700. 275 of them come in. So that's a cost that's borne in responding to the property, drugs, the nonviolent offenses that come into your system. You'll be seeing later on the cost of the probation parole revocation. This is just the new court commitments. Now, why do I share that? It's because there are some issues with every property drug population that we see across the country. This is Wyoming specific data looking at some of not only the drugs, it's on slide 27, the offensive conviction, but some of the assessment information. You have really great assessment information in Wyoming in the use of a compass score, which I'll cover in more detail later, ASI score on intake to prison, which allows this kind of analysis, and we don't always get it in every state we work in. So here's an interesting way to compare. If you look at the left large column there, the violent and sex compared to non-violent. So people who are in there for a non-violent offense, you see a higher proportion who are high risk. you see rough parity in terms of medium risk, and then right there. So you see a greater proportion of high-risk people admitted to prison who are nonviolent offense of conviction. On criminal history, you can see that they have, for medium or high risk, you see a greater proportion of people who are nonviolent offense conviction. Cognitive behavioral need, more probable or highly probable for your nonviolent offenses of conviction. And if you compare substance abuse need, 76% of your nonviolent offenses or people convicted of nonviolent offenses are assessed as having a substance abuse need, compared to 57%. That's roughly a 20 percentage point difference in terms of the needs of your property and drug or nonviolent population. So what this shows you, zooming out, I got too deep into the weeds, is the fact that your nonviolent offense, your people convicted of nonviolent offenses have a higher proportion of criminal history background, cognitive behavioral need, substance use needs. So they're coming into your system with a need for programming, services, supervision to address the behavior. So from a perspective of how you reverse the thinking errors that are contributing to the risk-taking behavior, the impulsive behavior, emotional responses, they need cognitive behavioral interventions. And until they have that rewiring of their brains done, they're going to continue to commit it. They're going to be interacting with people who are more likely to have antisocial views, to be in the criminal justice system. The hard thing is that people often work their way through many levels in the criminal justice system before they wind up in your prison. So moving these resources up front and moving effective supervision up front will reduce the number of them who move through deeper into your system and ultimately into prison. So we put this forward and also would like to back it up with the role that probation can play in being effective means for delivering that programming and services to reduce recidivism. Probation has a lower recidivism rate than prison for every category of risk, and have a lower rate of recidivism overall than people who go to prison. So when we look at people who begin a probation term and look at how many of them wind up in prison on incarceration within 3 years, it's lower than the rate of recidivism that someone has upon leaving prison and going back into the community. This is not Wyoming, it's not unusual to see this in Wyoming. It's in fact the trends we see in states across the country where we have this data available. That actual outcomes are better for people on probation, regardless of risk level, than people who are sentenced to prison. In part, that's because of the antisocial and negative elements that are associated with being in prison, especially if you are low risk, where you see the best outcome for probation. And while you're on probation, you can receive a combination of effective responses to supervision, plus programming and treatment. That can be a really effective way to avoid the antisocial, corrosive elements of being incarcerated while being on supervision and accountable with access to these various services and supports. And so then on this slide, we want to show that treatment delivered, where you deliver treatment, per slide 29, has an impact on the level of recidivism and impact you're going to see. So if you deliver treatment behind the walls, you can expect a 5 to 10% reduction in recidivism. If you deliver that in the community, you can expect a 20 to 30% reduction in recidivism, provided it's based on standardized, validated assessment, is combined with high-quality programs and treatment, and effective supervision all along the way. So I think there are different slices that you've seen at the populations that are entering into Wyoming's criminal justice system. And you can see that the people who are coming in with nonviolent offenses have certain characteristics that can be best addressed with the services and the programs and the accountability that will change their behavior. And until those interventions happen, you can expect the evolving work to continue swimming. This is the data's way of interpreting this information or providing this information. And if you talk to many people who work in the courts and law enforcement and other areas, they see very similar issues. You'll see a case later on today of people who have tremendous numbers of interactions with the criminal justice and behavioral health system. And until you can intervene effectively based on the level of need and risk they have, that door is going to keep spinning for recidivism.
Mr. Chairman.
Mr. Co-Chairman.
Yes, you talk about your sources. I can't quite read the print on this.
Yes, sir. This is from the, I think, Mr. Chairman, this is from the Washington State Institute for Public Policy. They did a meta-analysis of studies across the country. This organization in Washington does national research combining findings from reports across the country to inform their legislature and others about what works with interventions in criminal justice.
Mr. Chairman,
Senator Casey.
thank you, Mr. Pelka. The meta-analysis, maybe not now, but I need a bit more background on that. I mean, looking at the slide, what occurs to me is if I'm a judge, the ones I'm sending to prison are those for whom I have the least hope of getting them turned around. And if I'm allowed to engage in treatment in the community, it's probably because I think they got a better shot at getting turned around and they're safer in the community than in prison. So you'd have to tell me how this sample was controlled or balanced out to. I'm not sure that this is saying what you're saying it says.
So through the chair, as the senator, this is, so essentially what this reflects is studies across the country that track the impact of treatment delivered behind the walls and treatment delivered in the community, and look at all the outcomes and combine them all together to tell a bigger picture story of what the outcomes were across a variety of populations, a variety of states. And so I think it's some way of assessing where programs have the biggest impacts. And the slide you're also referring to in your question concerns the slide 28, which is the 3-year return to prison by risk. I think probation occupies a variety of different roles when the court is making a decision. And there are a whole host of factors that go into the decision about prison or probation. What this shows is if you view probation as a means of diverting someone from prison, regardless of risk level, people who begin probation have better recidivism outcomes over 3 years than people who go to prison and then come back to the community and are tracked over a 3-year period. So if you're looking, there's so many different dimensions that go into the decision about what's an appropriate sentence. And this is one way to look at appropriate populations for probation, what you can expect for recidivism versus their placement inside of prison. I guess one way to look at it. And I'll be talking a little bit about how sentencing guidelines extend discretion to courts in making that decision. This gives you a way of seeing what the outcomes are when you have similar types of people based on risk who go to prison versus probation. I think that's what we wanted to share about how that decision happens. And these are some observations of Wyoming's sentencing system that inform how decisions are made regarding placement on probation, placement in prison. And your system allows considerable amount of discretion at the court level for deciding whether someone's appropriate for probation, placement in an adult community correction center or an ISP as a condition of probation, or prison. And why I think that matters is in the absence of sentencing guidelines, providing advisory guidance on sentencing, it comes down to the individual judge, prosecutor, and defense attorney's perception of the ability of supervision and treatment to hold that person accountable. The previous slide shares the outcomes in Wyoming on probation versus prison, but it's going to come down to the decision at the sentencing level. So some states have grids or advisory guidelines that try to structure and provide consistent guidance. Wyoming doesn't have that. With some exceptions, your offenses are not ranked by severity as 3rd level felony, 2nd level felony. Each offense is listed individually. Your statutes guide how long the max sentence to prison can be, and the court may select any sentence below that max sentence. And so there's a fair amount for many of these offenses, a fair amount of room for individual discretion. The minimum sentence, which is attached to the overall sentence, determines when you become parole eligible, not including good time. And the statutes guide that the minimum sentence can be no longer than 9/10 of the max. So when you look at an offense on the books, you'll see a 0 to the max. And the court can select any maximum sentence up to that 10. And the min can be anywhere up to 9/10 roughly of that max. And the discretion is afforded in both those areas. And that's a product of plea negotiations, that's a product of sentencing practice in that jurisdiction, and a whole host of other factors. But what that means is it makes it really hard to predict what you're going to see regarding sentence lengths being set in your system. Most people who are convicted of offenses, except for those punishable by life or death, death or life imprisonment, are are eligible for probation. So there are no blanket exclusions based on types of offenses. It's really open discretion, which really means that how people perceive your supervision and treatment capacity can have a big effect on who's deemed appropriate for probation versus prison. And finally, there is no sentencing commission or statewide sentencing data collected in Wyoming or analyzed or reported. And so it doesn't, we can look at through our prison data how long lengths of stay are, that's how we can comment on that. But in terms of looking at your sentences on the courts and having some precision of knowledge about how they vary from one district to the next and how long lengths of stay are, there's no way to present that statewide picture. So that's I'm going to put that forward just to understand the kind of statutory foundations of some of the trends that you're seeing and ways that you could influence in various directions through public policy and budget decisions that are made at the court level.
Mr. Co-Chairman.
Thank you. If you look at the, when you're looking at that previous slide, some of the things that we had that we don't have that other states may have, factoring those in, and if you compared our crime rate to other states that do have those tools, so we have more crime, less crime than states who have that. I guess I'm wondering about the flexibility in jurisdictions. If that's a positive thing, or your suggestion of this slide is that's taking in the wrong direction. Based on our states, both crime rate and incarceration.
Great question, Mr. Co-Chair. And we have not done a comparison of states with sentencing guidelines, for example, compared to those that do not. I think that it would be hard to find a correlation based on sentencing kind of systems and the crime rate because of all the different factors I would want to account for regarding just a whole host of issues regarding they're separate from this structure of your sentencing system. I think one issue on the bottom there that I would be drawn to first is the lack of sentencing data available statewide and the lack of reporting about that data. That makes it really hard to make comparisons in those sentencing trends across the sentencing guideline and non-sentencing guideline states. I think one thing that I would also note is that there is no judgment or opinion to be issued on a state having guidelines or not. In some ways, those are deeply entrenched factors in a state. And what we would look at are what are the elements in guideline or non-guideline states, or the elements in all these different tools that some states have and other states don't. So this is a set of observations I would provide that there is no shift you can make to your sentencing guideline system to lead to more or fewer people being on probation. It really comes down to the local judgment of the courts across the state in determining what's suitable or not. So I feel that this will inform where policy options come from, because the levers you can pull, the changes you can make won't be the same as those that have these tools. So I would avoid any opinion or judgment on states having these tools or not, and instead look at how within your current system changes can be made to provide perhaps more predictability, more consistency, or greater clarity and guidance around the things you want to see in your system from a public policy level.
Thank you. Please continue.
Thank you. One thing that stood out, recognized, because a lot of the previous slide indicates, and this is slide 31, just a real shortage of kind of predictive policies on your books that can allow you to make those changes to your sentencing system to lead to different outcomes. One exception is the Addicted Offender Accountability Act, which is a really interesting framework, one that we don't see in many states. We see it in various forms. For example, identifying factors that make someone appropriate for probation. This is something special because it accomplishes sort of, I think, 4 at the top really interesting elements in your system. First is that it requires substance addiction assessment at the pre-sentence stage for anyone convicted of a 3rd DUI misdemeanor or any felony. So an ASI, assessment of service inventory, is conducted on anyone before their sentence to indicate their level of substance addiction need or drug treatment need. So you have information at the sentencing stage about your population being sentenced with a level of detail provided by this substance addiction assessment that many states don't have, or they rely on tools that provide very limited insight. Two, you have an adequate treatment alternative. The sentencing order contains a treatment plan that the person can be required to complete if they're sentenced to probation under AOAA. So based on the local availability of services, the court can require a treatment plan the person must complete. So it gives certainty in some ways. Its intends to provide certainty at the sentencing stage regarding treatment that the person will receive. So if you perhaps were persuaded by the slide showing recidivism outcomes, if you saw the impact of treatment outcomes, and you wanted that person to be on probation, through AOAA, you have the ability to require treatment in the community. Third, it defines a qualified offender population, which is someone convicted of a felony or a third-degree misdemeanor whom the court finds to have a need for alcohol or drug treatment. And then there's a rebuttable presumption against that eligibility based on the offense of conviction. If you're convicted of a violent offense or a delivery or unlawful manufacture of a drug, then you are presumed to be ineligible for AOAA. Everyone else that comes in front of the court that receives this assessment is prioritized or deemed appropriate for AOAA supervision and treatment. So in some ways, this sets a pretty high bar for what systems can use under this framework. That there is a structure in place in a highly discretionary sentencing system that if the courts have confidence in supervision and treatment, you can maybe increase the utilization of probation, increase the access to high-quality community behavioral health treatment. But what's challenging is that despite having this framework, there's very little information to know about its actual effect. We know that drug possession admissions to prison are up 46% over these 5 years of data. Does that mean that a smaller proportion of people who are eligible for AOAA are being diverted? We don't have information from the sentencing order to indicate why it's not being utilized or how it could be expanded. There's no kind of outcome from that structure. And second, we know that the 55% of your new court commitments to prison are for nonviolent offenses. So are there elements in how the eligible population is defined that could be modified to lead to more people using probation plus treatment? I feel that it's important to note these things under AOAA because it's something that states really strive for and don't often have listed clearly in statute. We were working in a different state, having never seen this framework, and we encouraged the state to adopt a treatment supervision sentencing option that a court could actually sentence someone to probation and require treatment. Because in talking to prosecutors and judges and defense attorneys, a big question is, if we trust this person to be on probation, can we be assured they will access program and treatment? Which is why many sections you'll see moving forward really delve into that topic of ability for people who are in need of treatment to actually get it. Because if probation is working and the treatment access is there, you can expect positive outcomes for probation that are better than prison.
Mr. Chairman,
Senator Kinsky.
Mr. Pelka, who would perform that function of tracking and analyzing and making recommendations on that data? Would that be the Sentencing Commission that you referenced in the prior slide?
I think my estimate would be the Supreme Court or the Department of Corrections. The Department of Corrections staff to carry out our involvement in PSI, the investigations at the sentencing stage, and the sentencing order, wherever it's produced, would contain some reference to that. That's the where it can be obtained. So we tried to wrap together some policy options from this first section, and this is the most on slide 32. This is the most limited of policy options. They increase over the various sections, and I struggled myself with why that was. And I think it's because this section really lays a foundation for what's to come regarding how you can strengthen supervision, how you can make your sanctions and incentives more effective, and how you can connect people to meaningful or high quality, timely treatment. So a lot of the ideas that are raised here will come and flow into future sections. Two policy options that emerge from us include the idea of providing judges with recidivism outcome data to help inform sentencing options, including probation, ACC, ISP, and prison. You'll hear more about ACC and ISP later on. But there are the ability in this state and everywhere to do annual recidivism analyses that are current and are based on your state's data to help to inform as one dimension of that case, whether this person could be effective on probation or other sentencing options. In the absence of guidelines and that, while you preserve discretion, you can provide more information in your investigations given to a judge before sentencing. And the second person, or Kisely's question, you've heard my reference to the idea of tracking available sentencing data. You routinely report the reasons why someone qualified for diversion, supervision, and treatment wasn't. I think that can be a helpful way of gathering information from courts and local systems in Wyoming regarding the ways that this framework under AOAA in your state is experiencing limitations in connecting people through this diversion option to supervision and treatment. It could be a way of you looking at in your particular jurisdiction, which could be rural, frontier, or more suburban, more urban. What are the factors that led that court to feel that probation plus treatment was inadequate? And that can help you to inform where to invest your resources, where to provide supervision responses. It can allow you to set targets for where you want to hit with your AOAA option and ways you can increase it. It almost connects sentencing information to public policy in that various way. Those are the two policy options we put forward. We are providing these in concept form to try to kind of outline some ideas you can develop moving on. And I think especially as the further options proceed, we'd be more than happy to provide more specific ways we've seen states address challenges through policy and other information like that. But before I transition to the next section, are there any questions from members of the committee regarding the section I just covered for wrap up? Happy to help any questions.
Committee, and then Representative James.
Mr. Chairman. I guess my question would be, if I'm hearing correctly, it sounds to me like when you're doing your study, you find policy more important than having the judges have discretion. While you were talking to the judges, was there any driver from the judges saying, look, we really need this AOAA so that we have this data? I understand the desire for the data, even for the judges, but I'm real cautious in wanting to take away a judge's discretion because they're on the ground, they're at the front lines, they know what their community can provide, what they can't. And so I'm real resident to want to moving towards a policy that they have to follow and at the expense of their discretion. You address maybe some of your interaction with the judges?
To the chairs, to Representative Jennings, I had a really great day yesterday, thanks to Judge Tyler and members of the South Supreme Court to actually present to gathering of district and circuit court judges yesterday. I've interacted with judges individually in Wyoming. I've really enjoyed it. This is my first time in front of them as a group. And so I was trying to compress all this content to a half hour I had basically. And so I gave highlights of all these different sections, including AOAA and its role in the state. I would say, if I were pressed by them meeting yesterday, same question just posed to me, I would say that this policy option seeks to preserve the full discretion that courts have under the sentencing structure, but instead collect more information about how this kind of framework is being utilized in Wyoming statutes. So, a policy that would structure, or I guess we say restrict their discretion, would require them to use probation treatment. In terms of looking at your sentencing system, it preserves so much discretion. It doesn't seem advantageous to adjust that here, but more information can shift how, in some ways, I guess, inform or encourage sentencing options if they deem it as appropriate. But these policy options, these approaches would do nothing to tie or restrict discretion, simply would provide them with more information regarding how, for example, recidivism outcomes exist for different sentencing options, or how they are responding to the use of the AOAA. Kind of a lengthy response to say, this preserves full discretion while collecting more information from the courts and providing more information to the courts.
Representative Dick.
Thank you. I think there's a principle of rule of law that we care about too, that we believe in the rule of law, and part of that means that similar cases should be decided similarly. So often across the state, the public thinks that's not happening. So most recently in Fremont County, had a case of non-consensual sodomy where the penalty was 20 days jail. Within the past 30 days in Seward County, a 19-year-old pleaded guilty to sexting using a cell phone, a one count, and was sentenced to 8 to 12 years in prison. So when the public sees that, they think that similar cases aren't necessarily being treated similarly. So I'd be amenable to looking at some form of guidelines just so we preserve that law. Different topic though, I noticed in your presentation, Mr. Pelka, it seemed that on the drug use in the southern tier of Wyoming, that the rates were up significantly. I didn't hear you talk about the causes of that. The time period here is 2013 to 2017. Of course, as we know, on November 6, 2012, Colorado legalized marijuana. I live in Rock Springs in Sweetwater County. I don't think drug use is up 72% in Sweetwater County, but people live there. I don't think it's down, but I don't think it's up. Similarly, I don't live in Carter County, but 165%, it's hard to believe that that's just because the drug users in Carter County suddenly are consuming 165% more quantity of illegal drugs, or spend that much. Does it matter for your analysis if what Wyoming is doing is spending its law enforcement resources reaching into the sewer pipe of I-80 and pulling out these drugs on their way to Colorado? Does it matter?
This is a great question. The ones that we struggled with too. We've certainly heard, even before we saw this, we heard that the increase in drug trafficking is coming from the south and moving its way up. There is nothing that I can cite in terms of the study to back that up. So here I'm referring to input that I received from various law enforcement executives. Very interesting to see it portrayed here in the slide. This slide depicts a number of case filings. Number of cases that are filed in courts, not arrests, not use, but kind of what winds up in court, which is affected by the previous elements and just how the response is happening. So in some ways, it's hard for us with what data we have and the input we've gotten to identify causes for these trends. We simply want to provide what they are and then kind of reinforce it with the perspective we've gotten from conversations we've had. This information, I think, is compelling to track moving forward. And it comes from one element in the case filing report, and it's helpful because it provides a statewide picture of that information. And that's I would say, but these are complex penalties and complex arrays of drugs. They're also complex interventions. There's interdictions across the travel corridors where the drugs are entering in. There are penalties to respond to people who are manufacturing and trafficking. And then there's a behavioral health element as well. And all is tangled up in this. And I hope this illustrates through data what perhaps people who are working in the system are observing or seeing or experiencing. There are just so many municipal law enforcement agencies comprising these big counties across Wyoming. I hope it's not satisfying of an answer, but I hope it gives context representative of kind of what we're trying to portray with this slide.
Members of the judiciary, I'd invite you to offer a little feedback at this point if you have anything.
I'm speaking personally, not as a representative of any other judge or court at any level. I think some of the things that have not been considered or brought up are, we are, as judges in imposing sentences, constantly trying to find information about the individual that we have before us in terms of a sentence for a particular crime. The felony crimes, there's a requirement for a pre-sentence investigation report, which includes this ASI assessment about use or abuse of alcohol or substances or both, that provides information for us to consider how do we treat in the way of a sentence this individual, given this individual's unique characteristics. There is this assessment that the Department of Corrections does in almost all the pre-sentence investigation reports that talks about the tendencies or propensities to be high risk, low risk, whatever, those inform us as well. We are required to consider a sentence of probation or other sentencing options over some sort of imprisonment. That is the first requirement that we are faced with in any sentence, and we have to announce that we have considered probation or other sentencing options before we sentence an individual to term of incarceration. I think that there is some indication in what you've seen so far about probation revocations having defendants return to the court and having their probation taken away where they are sentenced to incarceration. I would say that there are probably, I can't speak for every judge, but there are probably 2 to 4 probation revocations that have occurred before we get to that final option, that there's just nothing left other than incarceration, imprisonment. We've already explored ISP or an ACC program or something else that would prevent them from having to be incarcerated or sent to penal institution. So that, I guess I'm just saying that these numbers that we're seeing about probation revocations, returning people to a penitentiary sentence, does not account probably for the number of times that that individual or those individuals have been before the court for prior revocation proceedings, and then we just run out of options. So those are my comments. I'm sorry for the streaming. My name is Marc.
Thank you, Lieutenant. All right, Mr. Pelka, we've come to a junction here. Would you like to do another section and then take our 10-minute break, or take it down?
Mr. Chairman, over here.
Oh, there we are, the other guy.
Thank you. I have a couple questions if I can ask right now on this section.
Okay, that's fine.
Yeah, thank you, Mr. Chairman. So I'm curious about the correlation between, on page 16 of the PowerPoint, of Wyoming for the last 55 years having the lowest property and violent crime rates, 14th lowest property crime, and 11th lowest violent crime. And if there's been any study focused on the development of the Division of Criminal Investigation, which was implemented 45 years ago, with the primary focus really on drug arrests and drug crimes and investigating those, if that hasn't then resulted in what we see as an increase in Wyoming's drug arrests and drug crimes, and if then there isn't a clear correlation between having a lower violent crime rate, property crime rate, in exchange for a higher drug crime arrest and a rate and conviction rate associated with that. And if we lower the one, if we're not having an increase in the other. So if we reduce our focus on drug crimes, are we then in effect increasing our property crimes and violent crimes? If you looked at any studies associated with that correlation between drug offenses and violent crimes and property crimes.
So, I know that was that's a terrific question, Senator, through the chairs, and I'm going to try to answer it. And if I don't get at the heart of what you're inquiring about, I suppose invited on ways for me to provide more detail. The Division of Criminal Investigation, I would connect that to one kind of explanation for why the United States has seen a substantial drop in reported crime since the 1990s. And that is an increase in the use of effective policing strategies and timely, detailed information to law enforcement to inform policing and effective law enforcement strategies. Organizations and agencies like DCI collect and provide that information to members of law enforcement through a variety of means, including your criminal justice information system and ways that knits together information across the system. And what that leads to is more in-time and more reflective information about trends in your system, which help law enforcement direct its activity to respond to crime. So when we look nationally at why the United States crime has dropped in the way that it has, that is one part of it. There are a number of other sociological elements. There are changes in consumer behavior, in terms of alcohol use, in terms of demographic information that all contribute to something that reflects the overall U.S. Drop in crime. Something that's fascinating, and read about a lot, and should be further explored. On the topic of the impact of sort of response to arrest and the impact specifically involving drugs, the drug arrest provides a large volume of activity across all states. It's a large volume. It's 16% of all arrests in Wyoming, and I've seen that be the case in most states, somewhere between 15-20% of the number of arrests in the state and across in that given state. It'd be interesting to see nationwide across all 50, but in my observations, that's what we've seen. Part of what I think would be really interesting to get the senator's question is deep digging into the drug arrests and see how many of those drug arrests were involving people on supervision or under no supervision whatsoever, and also people who had prior involvement in the criminal justice system. That can tell you a lot of information involving those arrests and what's driving law enforcement activity. Are members of law enforcement in a given jurisdiction re-arresting people who are recommitting crime and not being held accountable through the variety of means available in Justice Center? Are these new people coming in, relocating, or coming in from over the border? That is where I'm at right now. The senator's question is really where you delve into how effective policing and enforcement strategies can tackle things like increases in drug arrests and provide accountability to slow that revolving door so that law enforcement are not focusing on people who are repeatedly turning up through that revolving door recidivism, but rather complex and challenging cases involving law enforcement. I would add that the senator's question is so rich, I want to tackle so much. I hope I got at it. I'd be happy to elaborate further or be guided accordingly.
Rich questions. Forte.
Mr. Co-Chairman.
Thank you. Back over on slide 32, under those policy options. First one seems pretty straightforward. What do you expect from that second? You talk about analyzing available sensing data and team report. Is that, I can envision that happening.
Thank you, Mr. Chairman. And I think since the first time we're kind of releasing this information in a group, I think the elements that are part of this involve first information technology and case management systems. Is this information or pre-sentence investigation data already available? It just has to be pulled and analyzed and reported. If that's the case, pretty straightforward. If it requires some new data undertaking, or if it involves investment of staff to do it, it'll cost more. Ideal scenario, this information is collected and stored and just has to be pulled and presented. In that case, it's pretty straightforward, light lift. The challenges would be encountered if it requires some new data system or some new staffing.
Who does that? Where does the information go?
Mr. Chairman, rather, it goes, I think it's collected, reported by the courts, and could exist in the DOC database. So it's somewhere between those two, that branch of government and that agency, where that information would ideally be located.
So you're saying this is a responsibility in court to gather that and analyze it?
I feel, Mr. Chairman, I think it's shared in some ways because the DOC staff carry out the investigations. And so that data could be in their database or it could be in the Supreme Court where that exists. There are a variety of ways to get at it, and we definitely would like to develop more detail on how this could be carried out. That's the overall vision.
Mr. Co-Chairman.
And I guess this is for the judges, if we talked about that particular sentence, that paragraph, any input is already happening, is it something you're feeling there's a gap that was needed, or this is an exciting concept?
before we go forward, I'm Lily Sharp from the Supreme Court, and I thought it might be helpful for the committee to know when all judges are here, so that as they answer the questions. So if, can I start for you, Judge, please stand up. Or introduce yourself.
Hi, I'm Judge Donna Snyder from Bourbon County, 2nd Judicial District, and been on the bench since
I'm Judge Steve Sharp, Wyoming County, Cheyenne.
I'm Tim Day from the 9th Judicial District in Jackson.
Marc from the 9th Judicial District in Wyoming, Suffolk County.
Judge Day, yeah, either personal opinions or share conversations?
Yes, thank you. Well, just going back to the Addicted Offender Accountability Act, I think it's important to know that that is alive and well, and what happens in every sentencing in a district court is that there's a substance abuse evaluation that has to be done because the person before you is there for a felony offense. And so the substance abuse evaluation recommends whether this person is in need of substance abuse treatment. And if they are, then the Offender Accountability Act requires the judge to say, okay, are you a qualified offender under the Accountability Act? It looks like you are because it's recommended that you have treatment. And then there's a presumption that unless the person is a violent offender or manufactured drugs, then there's a presumption that that person can put on probation with treatment. The judge can then make a finding that for whatever reasons this person shouldn't be put on probation. And as Judge Tyler mentioned, under the sentencing protocol, we have to consider probation and state on the record if we incarcerate someone that probation has been considered, but for various reasons, the judge will not put them on probation, instead has to incarcerate them. And of course, that depends on the circumstance of the case and the goals of sentencing. Case law has developed the 4 goals of sentencing: retribution, rehabilitation, deterrence of the individual, and deterrence to others. And so those are all part of that mix at sentencing. And for me personally, it's rare that I would have someone who is a qualified offender in need of treatment that I wouldn't consider strongly for probation. To the degree that this policy option suggests that we can get more feedback about which individuals are qualified offenders, but for various reasons are not being put on probation. I think that would be helpful to all judges. But my personal experience is that most often we'll do whatever we can to put them on probation if that's consistent with the goals of sentencing and public safety.
Mr. Coachman.
Thank you. Just getting back to the judiciary, Judge Snyder, since we always go with the best and the brightest as we move forward, how are trends in Wyoming with sentencing and effective crime reduction compared to the rest of the nation, state by state? Sorry. Never. You have that answer.
You are so learned that I'm sure that you have a lot of information in that area already. And I think that your presenter probably
Okay, more serious question though, and this goes back to what the representative, he talked about 2 different cases in 2 counties and the difference. He talked about different outcomes. I guess my question is to the judiciary across the state. recognizing, and this isn't all in your report, it has to do with law enforcement, prosecutorial discretion, but also the judiciary. Is there value in local priorities? For example, a community that may elect or appoint law enforcement and prosecutors, and it says we have zero tolerance for a particular crime, maybe it's a marijuana crime, or we have a higher tolerance for shoplifting or tobacco, or some of these other type of crimes. And the reason I ask the question is, how, your ideas or your input or your experience on should community priorities play a role, or should we see more of a standard sentencing scheme that covers the state?
Marc Tyler again, and again, I'm only speaking in my capacity, not in representative capacity of any sort. I probably have one of the most unique positions in terms of a district court judge in the state, in that I am assigned cases on a regular basis in Fremont County, both felony cases and civil cases, as well as the cases that are almost all assigned to me in Sublette County. I also take cases where there are conflicts or other reasons that have been assigned to me from other counties. And I've had some cases, for example, in Teton County or Lincoln County involving felonies. I've had some in Park County, fairly much all over the state, except for perhaps the eastern part of the state. And it's not just a handful of cases, it's generally a number of cases. And when I describe my sentencing philosophy to defendants, a lot of times I'll bring up this very thing you're talking about, Mr. Chairman, that there are community ideas that there's a certain amount of attitude or there are mores in the community about certain kinds of crimes. There's an emphasis on being, I guess, tougher or more strict in their view about certain kinds of offenses in one community compared to another. And I picked up on this, particularly between Fremont County and Sublette County. There's in many kinds of offenses, there are different views about what I perceive the community more or less expects a judge to do or how to handle certain kinds of offenses just between the two adjoining counties. I picked up the same thing in Teton County, which generally you're from Teton County. I think you're aware that Teton County has different ideas than Sublette County and their adjoining counties. So I've added this as a consideration in my sentencing philosophy, and I've announced it to defendants that I've considered that particular factor. I think other judges do that, but they don't discreetly identify that factor as one that is at the top of their sentencing philosophy, because most judges usually handle cases in their county or they're assigned in certain districts, a couple of counties that they have cases, but for the most part, like Judge Sharp is in Cheyenne. I don't want to speak for him, but I don't think he handles cases as commonly outside of Cheyenne that like Judge Day, primarily in Teton County. And so I think that is an important consideration, and we do, I think, recognize it. I don't know if I've answered your question.
Mr. Co-Chair.
One of the reasons I asked the question was when we think about those other tiers, whether it's law enforcement that is headed by an elected sheriff or chief of police who is appointed by electeds, see quite often, I think, a real local priority on what laws are enforced at what level. And then it's the same with the prosecutors. And so I wonder if there's any concern with the judiciary about some harder standards, and if that puts you in in conflict or that steadies the vote. Where one group is, so this is where the boundaries we want you to work in, but everybody else can kind of do what the vote is. That can get a better outcome, that help us to hurt us.
Marc Tyler again. If I'm understanding what the question is trying to get at, it's, I guess I'd say it this way. We are handed the case that we have to deal with from law enforcement and prosecutors using their discretion. And we don't have a whole lot of control over what cases are brought before us other than the influence of those officials, law enforcement, prosecutors, and defense attorneys, and that sort of thing. And so I don't know that there's really a way that we can make those kinds of decisions. We have to deal with the individual that we have in front of us. We have to deal with the offenses that that individual is committed. So I'm sure I didn't answer the question, but I apologize.
Thank you. Good chart.
Mr. Chairman, members of the committee, a lot of very important issues that we're all addressing today. I can tell you just from my own personal philosophy in terms of sentencing, I'm hard part of being a judge and having to send somebody to prison. And I think most judges approach it in the same manner. You look for options short of that if you can. You value the information that you get from the pre-sentence report. You look carefully at somebody's criminal history. You look at the substance abuse assessment to see if there are problems, if there are mental health issues that need to be addressed. And you try to factor all of that into what is an appropriate sentence. And then you try to follow the Constitution, which says we look primarily at reformation and rehabilitation as the primary option. I think in Laramie County, Judge Grant used to say you have to work really hard to get to prison. And I think that's really true. I mean, we'll put people on probation, and it's usually after about the second or third revocation, sometimes even more, before you exhaust all your options. You exhaust the ISP, you exhaust the local corrections programs, and really the personal and permanent bridges, and there really aren't any other avenues available, unfortunately, other than to send that person to prison. One of the things that I was sitting here listening to and getting a little concerned was this notion of sentencing guidelines. I can tell you, I worked in the federal system for 10 years in my prior life as a prosecutor, and I think that was a calamity. You look at the war on drugs from the 1980s going forward, with mandatory sentencing guidelines, the federal prison populations exploded, filled up with a lot of nonviolent people who a lot of times were just sucked into a conspiracy because of their relationship with somebody else who was dealing drugs. To the point the law changed now on the federal stage where sentencing guidelines are just recommendations. I think all judges need information. That's the most important thing that we can get. The most information that we can get, hopefully the best decision we can make when it comes to sentencing. I think taking discretion away from judges or saying that, you've got to get this person based on their criminal history and based on the nature of discharge. 36 months is not a solution. And that's primarily from my personal experience in the federal system, a decade of dealing with sentencing.
Mr. Chairman.
Senator King.
Not to jump ahead too much, but as long as the judges are sharing with us, I'm curious, besides the fact that you do everything you can to bring the prison, do you feel like you have all of the options and all of the resources you need at the community level to help people with prison? And specifically, I'm thinking about the mental health centers are chronically underfunded. Their funding is in danger every single year. We've got trials of medication-assisted therapy, but that has not been spread throughout the state yet. 24/7 has yet to hit the whole state. Are there other tools that you'd like to have that you don't have that could help give you more options in terms of avoiding prison for some of these offenders that might be more effective or better funded than the options you have now.
Marc Tyler again. I'm sorry, I keep jumping up here. Marc Tyler again. My jurisdiction, my primary jurisdiction is Sutherland County, contrasted with what's available in Fremont County. I'll just give you some examples. I do not have intensive supervised probation available in Sutherland County. There is some intensive supervised probation available in Fremont County. We have no inpatient treatment programs available in Sutherland County. Probably the closest ones that we have are in Rock Springs and Sweetwater County. There's a lot of people applying for those programs down there. There's a stiff competition for bed space for inpatient treatment programs. There's a waiting period, usually involved several months for application, getting an actual bed date to be able to start inpatient treatment. And I'm not being critical about it, but I'm just saying this is what I see and what I have to consider on what can I do in the way of probation or sentencing, those sorts of things. You've noticed that all the ACC programs are in the eastern part of the state, basically. Nothing in the western part of the state. Those beds are limited to, and they accept people who are rolled out of prison into those ACC programs as well. There is one inpatient treatment program that I'm aware of that if the individual defendant is in custody, it lengthens the amount of time before they can be accepted into a bed date by as much as 5 to 6 weeks. 2 to 3 months. If they're not in custody, it speeds up the possibility of getting an inpatient bed date. Those are some of the things that, we have these options available to us, but in terms of the realities, it makes it more limited in terms of our options and our ability to refer an individual defendant to some of these other things that we would like to see. I have right now an individual sitting in Sutherland County Jail awaiting acceptance into an ACC program. And so he will sit there until we either find out he's accepted into an ACC program, or if he's not accepted, then we can bring him back some YSP or something like that to accomplish the goals. The other thing I want to augment Judge Day's explanation about consideration about the ASI evaluations, the Individual Offender Accountability Act requirements. If we send someone to a penal institution, we will give recommendations to the penal institution. We can't tell the executive branch what to do, but we give recommendations, and we do using the ASI evaluation. There's an inpatient treatment program recommended for diagnosis recommended for an individual. We will say in a judgment sentence to the Department of Corrections, this individual needs treatment, and we recommend that he receive treatment at the level diagnosed in the ASI evaluations and the recent investigation report. I've never had the Department of Corrections refuse to accept the recommendation. It may take some time for that individual to get into the program once they're there, but I've never had that done. So, I don't know if I have any questions.
Sure. Mr. Chairman, thank you, Judge. I think that was enlightening, and it goes right to the heart of what Justice Reinvestment is all about. If we can find a way to take the millions and millions of dollars we're spending on prison and use it for these community-based options that are in short supply, we may actually improve lives and reduce recidivism. So thank you for that. I didn't realize that. I guess I know that parts of rural Wyoming are resource strapped, but it didn't occur to me that these resources were so uneven across the state, and that's helpful. Thank you.
I'm sorry, Representative Olson, we simply have to move on. So I hope you can ask your question privately, or maybe it will get covered later in the afternoon. But I'd like to give the group a 10-minute break, and then we'll be back in session and pick up on the next section on the connecting victims and crime to trauma-informed services section. I'll call you back in 8 minutes, and we'll be back in session. You have opportunity to speak. Also, I would remind the committee that tomorrow morning, in those 2 hours at the beginning of the day, we set the time aside to discuss these policy options in more depth. So there will be dozens of ideas spinning in everybody's heads about all of this. And we have set aside some time to try to nail some things down in those 2 hours at the beginning of the morning. So our next section is connecting victims of crime to trauma, informed services and support. So Mr. Pelka, would you take over?
Thank you, Mr. Chairman, and members of the committee, and I'll just be here at the beginning of this section to introduce my coworker, Grace Paul and Kara Chambers from your state. We saw in the last presentation a lot of content regarding crime and arrest information, and we focused a lot on the responses available to people arrested and convicted and sentenced for various offenses. This is going to be a really powerful section to look into the victim's experience, and on the other side of a violent or sexual crime, other side of the property or even a drug crime, they're often our victims. And this section seeks to explore to what extent victims are able to access services and supports to address their needs in the aftermath of crime. And Grace is a resource nationally on issues involving victims, and she's been analyzing issues involving Wyoming, and through that process has gotten to know your Director of Victim Services at the AG's office. And so this will be a co-presentation involving Grace and Kara. And I'll be nearby, but I'm really excited to introduce Grace to you. And without further ado, Grace, please give you a approach.
Good morning. My name's Grace. I actually come to you from Iowa. The other folks live in bigger cities, and I'm the rural remote folk that get to come and work around the states. But I did want to just make a quick mention about Wyoming. My grandma was actually born in Acton and is buried there, so it's always nice to come back to the area and the place that I grew up in and loved. So I do love this. It's current. A couple of things. One of the pieces that's most important when we talk about victims of crime or we talk about public safety generally is to think about the critical role that people who experience harm or violence play in our criminal justice system, right? We're trying to think about how criminal processes and investigations even start and why victims are so critical to the process. When we look at public safety more broadly, we're looking at how do we reduce those first-time instances, how do we reduce second time or other offenses, how do we repair the harm that was committed against people who were harmed, and then how do we sort of build that community trust and improve the overall expectation that folks have about community safety and being able to just have a high quality of life. In this section specifically, and I'm really glad to have Kara here, Kara and I go pretty way back. I used to have a similar role to hers in Washington State, and so we've done some work together for a while, and it's always nice to get a chance to work with her and talk to her. It's been great to talk with Kara and her staff about some specific Wyoming details and learn a little bit more and provide some context to some of the data that we actually pulled and looked at. But one of the pieces is we want to look at, when we're talking about public safety, when we're talking about crime and violence, we always want to look at what's the immediate effect and how quickly can we deter the immediate effect of crime and violence. There's a lot of data to support that. The quicker you address the aftermath of trauma, the more likely you are to reduce longer-term impacts like substance use, mental health issues, and other maladaptive behaviors that people develop, sometimes in response to crime and trauma and violence. There's three different things that we look at when we look at crime victim systems. We look at crime victim compensation programs, which is housed in the AG's office here in Wyoming. We look at assistance programs or grant funds and how they support your victim services throughout the state, also housed in the AG's office. And then we look at restitution, which is how are people's sentences reimbursing or supporting recovery and healing and accountability to victims who experience crime and violence. So we talked about this, and I'm sure anytime you look at crime and violence from a public health perspective, then you're going to learn and hear about how exposure to violence and trauma in someone's home, in someone's community, where someone works, where someone learns has a negative impact and can have a negative long-term impact on someone's overall quality of life. So one of the ways that we counteract this, right, is we do earlier, swifter, easier interventions to hopefully start to contain this cycle of violence or the cycle of experience that helps people heal quicker and get back effect like they knew it before. There is a strong association with mental illness, substance addictions, and incarceration. Obviously, as we talk more about the community health resources, when we talk about behavioral health, I do really want to underscore that there is an association when we look at adverse childhood experiences, when we look at what drives people to different criminal behavior, what people are coping from, what they're managing, we do see a really strong correlation. And it's something that as an investment on the front end could have a longer term payoff, right? It's just overall quality of life, reducing the contact with the criminal legal system, and then also just making sure that people recover and heal from violence.
I have lost my voice. I'm mostly the Vanna White up here to any presentation, but I did want to throw out that if there are any, state-specific questions, then I will do like Grace roll on.
Thanks, Karen. When we talk about crime victim compensation, every state in the union has a crime victim compensation program, as well as DC in the territories. At the Council State Government's Justice Center, we had the opportunity to do kind of a legal statutory review of all 50 programs. So we have a nice framework to look at how's Wyoming doing, how does it look, how does it compare to its neighbors. But the thing that's important about the crime victim compensation program is that your amount of federal dollars that match your state investment to your compensation program are determined based on a formula basis. So every dollar that your state invests in this program, the states essentially match, right? It's a 60-40 split, so every dollar gets money back. But I do think it's important to know that whatever the state invests, that is also support. Eligibility varies by state, but it's really important to also know that in order for a crime victim to qualify for this program, they have to report the crime to law enforcement. They have to participate in the investigation of the crime, and then this also is a payer of last resort, meaning they have to exhaust all of the resources before they can tap into the benefits of the crime victim compensation. There's other eligibility pieces, there's some contribution stuff, making sure that the victim didn't contribute to the offense, and that the benefits kind of vary based on what people need and what they ask for. So they can have, folks can request reimbursement for funeral expenses, for the homicide of a loved one, they can do mental health benefits, they can do lost wages, and a couple other things here in the state. But again, these are direct expenses that a victim can substantiate that they are reimbursed for by the state based on the eligibility requirements. I do think it's important to also recognize that every time someone applies, right, it's a real life victim that's requesting something that's a direct expense related to a crime that happened to them. Typically, these programs reimburse violent crimes. That's the case here in Wyoming. But I do think it's important to know that there is someone on the other end of these crimes that has tangible, real financial losses directly related to this crime. So one of the examples, and we've heard stories, and Tara and her folks here in Wyoming have examples of people who directly benefited with low balances in their bank account, when a check hits, and make sure that they don't have to go into further credit card debt, they can pay their rent, they can pay their insurance deductible, they can get their car out of impound. There's real tangible expenses that people are managing.
One of the things in Wyoming is quite good at is how quickly we can get money in order to a victim in need. In fact, I attend national conferences and usually give a little asterisk, well then there's Wyoming, and they just skew our statistics. Because we can get money out the door within days from receiving an application. We have, obviously a lot larger states like California that have 12 to 24 month delay. So I just want to let you know, Wyoming does a really good job of making sure that when we have identified a victim, received a claim, that we, although we're a small state and we're a small staff, that we're able to process these claims and get that money out the door quickly. It's really, when you're trying to aid in someone's restoration, speed is, time is of the essence.
Primarily, the expense that folks are requesting in Wyoming is a medical expense reimbursement, which means I've gone to the hospital, I was in an assault, and I have medical expenses that are beyond what my insurance can cover. And this program is supporting a lot of those efforts. It also means that hospitals are kind of helped through this program, right? They're not having to take on too much additional debt when they're helping people who are victims of crime. So it supports a lot of different industries and individuals specifically. Your second highest is mental health. This is one of my favorite things about Wyoming. Sometimes we have states that have difficulty connecting connecting victims to mental health services, which is like a key connection if you're gonna deal with like immediate trauma impact and helping to change how someone recovers and heals from a crime. So it's pretty exciting, and Wyoming's actually, I plan on tapping into Kara a little bit more to help other compensation programs figure out how to do this benefit better. And it really speaks to the quality of service that you all are providing. If you look at the region, right, if you look at your neighbors, and I think it's important to note that Wyoming, y'all are doing a good job. This is a great program here, and I'm really impressed with the way that Kara and her staff administer. You should feel very proud of the stewardship that they're taking over these funds, but also the swiftness and effectiveness and how they're helping people who experience crime in your state. One of the other things we look at is how much benefit. When we get to the policy options, I'm going to share with you a couple things that Kara and I talked about that would help the program. One of the things that's nice is if someone's a victim of has catastrophic injuries in the state, Kara and her team have the ability to exceed the maximum benefit and help us with the longer term medical care expenses. Some of your neighboring states have that same thing. And I also wanted to just point out that when we look at data in your state and we talk about this benefit, we also like to look at people are maxing out, like how many people in the state need more than the state can actually provide. And when we dug a little bit deeper, we found that there was only 56 claims and there wasn't really a need to look at that underlying expense or increasing your overall maximum benefit. But to really think about it, there were other ways to make the program easier and more accessible to people, which Karen and her team are super open to.
And maybe one thing that I can add about, we like the data shows, we don't see a lot of claims that reach the maximum. But when we do see those, they do it very quickly because they're very serious injuries that may result in lifelike larger hospitals, which I don't know if any of you have ever seen a lifelike bill. A low end would be 50,000 to 250,000 just to get someone to a higher tier medical facility. So when we do max out, we're doing it very quickly, unfortunately. But, you know, I can be very protective of our program, and I see that, you know, we're lower than the surrounding states, and I do feel, I want you to have confidence in the fact that I do feel the Wyoming State Compensation Program is addressing really good concerns.
There is some language in some of your administrative rules and policy that guides this program that says that people only have 24 months to access these benefits, and that's something Kara and I have talked about, is extending that or allowing people good cause, which means should something come up 3, 4, 10 years prior to the crime, and if I still haven't reached my maximum benefit, maybe there's an anniversary of a homicide, maybe there's a relocation, maybe there's a release, maybe there's a parole hearing, that someone has the ability to come back to the program and say, I have additional medical, mental health, or other needs that I would like to have addressed and helped with by this need. So that's what we're looking at. I had talked about this. One of the strengths of the way your compensation program operates in Wyoming is that you rely a lot on victim advocates in the field to connect folks to the compensation program. They're helping gather a lot of the paperwork, which is actually a model that we're using to replicate in other states across the state, hopefully starting in October. So like you're paving a path, you're showing states how it can be done, and you're helping improve some of those efficiency pieces like Kara talked about to get victims benefits more quickly. One of the areas that y'all can improve is the way that funerals are being reimbursed. If we look at sort of the average cost of a funeral, we look at burying someone versus cremating someone. This is a place that Wyoming has an opportunity to grow. And I'll let Kara kind of say, after we talked to her about this and shared this data, they were able to make some changes.
Yeah. Well, I mean, just like Grace said, it's one of those things that, you know, fortunately we don't see the level of homicide compensation that, you know, obviously larger jurisdictions do. But when the Council State Government was able to do this sort of deep dive into our data, we realized we were obviously behind the national trend. We have one claims analyst in our state, and she went and spoke to the Funeral Directors Association. And we realized that, yeah, we were behind on what we capped out at 5,000. So fortunately, that is an easy policy change. It doesn't require statutory change. So we have done that or doing that. Because we really do realize that when a family is, you know, obviously we're compensating family survivors of a homicide, that the last thing that we want victims to be worried about is the type of burial option. and we realized that with the 5,000, that was, like, as Greg said, limiting it to cremation. We'd like to offer benefits to allow traditional burial if you wish. So just sort of, you know, a happy note of having this analysis that really did change some internal policy around this. For the benefit.
Grant funding is another significant investment that the state and the feds make into Wyoming and how victims of crime are managing and recovering. One of the federal resources y'all may have heard about is the Victims of Crime Act funding, or VOCA funding, which has increased exponentially since 2015. I did think it was important to note that in this state, so this is a population-based formula, which is also important and has an impact in Wyoming. Obviously, we don't have a way to quite, that's haven't figured out the way to satisfy for geography versus population. And doing most of my work with victims in Utah, I can tell you that geography adds an expense that a lot of people can't really recognize, right? It's very expensive to make sure that our most rural and remote folks have access to services and treatment that they need. And so this is a population-based formula grant for the feds. It's 100% funded through federal fines and fees and forfeitures, so not a zero drop of tax dollars goes into this, and it's something that Congress allocates money towards. But again, they're allocating money that's fines, fees, and forfeitures, and not in zero tax dollars. In this state, it primarily supports services to victims of domestic violence, and then when we say underserved victims, we're mostly talking about services through your victim witness programs in a prosecutor's office. That's helping folks of, aggravated assault, DUIs, homicide, and some of those interpersonal violent crimes that are not domestic violence or sexual assault. When Kara and I started talking about sort of the distribution of these fundings and how they're spent, I was excited to learn that Wyoming is actually currently hiring someone to do a needs assessment to make sure that all the pockets of the state have all the services. When you see the numbers on this, in each of these counties or areas of the state, you'll see like each one of these correlates with the number of programs available in that county. And the part that's important is that sometimes this program is a domestic violence program, sometimes it's a child abuse, child advocacy center, sometimes it's a multi-purpose program. But what we want to try and do through the needs assessment and what CARA staff is doing is making sure that everyone throughout the state has access to whatever program they need, right? There's a couple of statewide programs through the Border Patrol as well as the Access to Justice Project. So there's opportunities to get folks the services they need statewide, and the needs assessment can further help address who's missing or not getting what they need. Finally, restitution is a thing that we always look at. And in your state, y'all know this, right? The crime's reported, law enforcement investigates, prosecutor picks up the charges, submits to a judge does the sentence, and then it goes on from there, right? The prosecutor works with victims in your state to determine if there's pecuniary damages. This is often included in the pre-sentence investigation report, but essentially works with the victim to find out what's the financial burden of the crime that happened, and then it's included in the sentence. All y'all know that sometimes when we're looking at restitution, we're often looking at the ability of the person who's accused of the crime to pay the restitution, right? So I would also offer that when we look at restitution, we always want to look at your crime victim compensation benefits as well as your assistance benefits, so that on the off chance the person who's accused of the crime or sentenced because of a crime they committed cannot afford the restitution, that there's another place for the victim to go to get his or her needs met, and then we're not relying on the criminal justice and a slow restitution collection system to meet the immediate needs of someone who was harmed. Your Department of Corrections has the ability, sir, Representative.
Thanks, I appreciate the chart. I just wanted to, as a defense attorney, wanted to point out there's nothing in there about a trial.
Point of order, taken. Thank you. When we look at restitution, we're also trying to look at how it gets collected. The piece I like about restitution is that if everybody just does their job, a little bit of their job, then their progress can be made towards meeting someone's sentence and paying off restitution, right? So this means that from Department of Corrections making the deductions that they're able to from inmate wage accounts when they're able, from someone, probation officer following up with someone to make sure payments happened at the court, to the court dispersing. You have a lot of different players when it comes to restitution. It's a pretty elaborate and expensive process and requires a little bit of coordination. But the good news is with additional coordination and communication, you make a lot of progress, and you can see people complete and pay off restitution by the end of their sentence, as long as they're making those small income.
And I wanted to add, while we're very fortunate that we have crime compensation and that does come in quickly and is able to aid with medical, mental health, what have you, it's so important that we still understand that their restitution isn't necessarily, to pay those direct bills, it's to pay back the system and to have that offender accountability. And I would rather continue to receive the $1 a month check from an offender to have that monthly reminder of what the impact it had that goes directly back into the crime investigation than worry about how much of the blood from the stone analogy that I would rather have that trickle in and have that mechanism in place to replenish the fund all day long, and let us worry about it as opposed to ignoring what's our constitution. And my only request, and one thing that I think Grace is about to touch on as far as communication is, I think improving our restitution collection can really boil down to just communication. I think oftentimes, maybe not often, but sometimes you'll have a victim who comes in and maybe prosecutors ask, do you have any bills? And the answer is no, because crime victims comp pay. But crime victims comp is still that obligation. We have the statutory mechanism for that to be ordered directly to crime victims comp, and I just want to sort of throw that out there again. That restitution is more than just making sure those bills get paid. It's the crime and punishment component of you are paying for what you do, literally.
And to further underscore what Kara just said about compensating, the crime victim compensation, being able actually to request restitution on behalf of a benefit they paid out, I also wanted to just show what it looks like in Wyoming, because people can and are making payments on their sentences and restitution. And there is a nice, I really like the way Kara said that there's a nice way for the state to actually pay the victim immediately and then get reimbursed for the person who committed the crime on the back end. There's something very nice about being able to meet the immediate needs and not have the victim worried about whether their $15 or $2 or $70 to $5 check is coming every month. So it's a nice position to be in. One of the things Kara and Lily and I have all talked about, Lily from the courts when we're looking at restitution is, are there ways that we can improve communication to improve the way that restitution is collected and monitored and administered? I know Lily and I have connected, and I know the courts is undergoing some kind of claims management system overhaul. And so right now, even though we don't have a lot of data available in a easily extractable way from the court, that's something that her and her team are looking at is as they're developing this new claims management system or courts processing system, what are the ways that they can make restitution information easily extractable and reportable? And obviously, Lily, if you have something to add, please jump in. But obviously, it's a better use of time rather than have someone customize a poll right now of data and spend a week writing the code to make that happen, to increase the communication between the courts, between the AG's office, between the DOC, between the county clerks, and then figure out a way of what's important, what we really want to know about restitution, and how do we make sure in the future system that's easily accessible. So, anything to add?
No, I agree.
So just to, just as a wrap up of sort of where we're at in Wyoming and the policy options that we're looking at, as we touched on, extending the benefits and the ability for a person to access benefits beyond that 24 months, improving and increasing the federal funeral amount, the federal amount that people can access are things that CARE is already working on and investing some staff time and resources in developing. There's going to be a needs assessment. Not only is this going to tell us and make sure that people around the state have access to services, but it's to point out populations that we're missing, specific crime victims that are underserved, or different types of services or evolving needs of victims that Karen and her team could develop new RFPs for, new opportunities to expand the programs that are currently serving folks, new ways to provide services, and I know that's something that and then finally, just to underscore, with the lack of information that's available right now in an easy, not time-intensive way, it's been nice to start the conversation with Lily and the courts about how to make sure that we can produce this information, that we can, let's segue real quick back, but When we have studied restitution in other states, one of the things that knowing more about your restitution processes can help is understanding the average amount of restitution owed per person. Sometimes what we see when we break down restitution into a per sentence number is that it's actually more manageable than we think it is. When we tend to think of restitution as like $100 billion or owed victims is this outstanding pile of money that no one can collect, then the obvious immediate reaction is, who on earth has that kind of money, right? But if we break it down by sentence, and we found this recently in Iowa, we found this recently in Hawaii, your average restitution order is less than $1,000. And if we think about that over the term of someone's sentence and making little incremental steps towards paying that off, it helps address what Kara is talking about, which is the reason victims really care about restitution. They care because it's a piece of accountability. Rarely do they care about that check. I promise you, they're not holding their breath waiting for that $3 check that's going to buy them a Starbucks latte on their way into work. They care about it because it means you all are doing your jobs. It means that someone's taking responsibility and accountability for the entire person's sentence. And that's what it really means, right? So any progress we can make towards managing that or improving the communication about it is only going to send a signal to the victims and people in your communities and jurisdictions that the whole sentence is being enforced. Any questions, Chairman,
Committee?
Co-Chairman?
Representative Bison.
Thank you, Mr. Chairman. I guess this is probably for Director Chambers. On page 40, when we talked about the maximums, and we're at 15,000, and it says in fiscal year 2016 and 2018, we had 56 claims maxed out. Do you have any idea how substantially more than that number is for those 56? How close were they to 15? How many were like way above that? Like 100,000 of our range, whatever.
Jim.
Chairman, Representative Biden, anecdotally, kind of what I said before is we'll get those claims that hit the max immediately because the outstanding bills are far in excess of 100,000 plus. Off the top of my head, I don't have exactly. But yes, so what happens is when we have a claim that maxes out, it's usually because it's far in excess. Nothing to where I would recommend, raising our statutory cap, because we're not, the ones that max out, we're never going to do that because it's so great. I will let you know that we have a really good relationship with hospitals across the state who understand that when they have a bill that's being paid through primary compensation, they will almost uniformly write off the remaining balance because they do understand that this is sort of a different circumstance. This was a victim of a crime, and that we're exhausting the resources we have. If you'll see the note in the corner, we do have that additional 10,000 that's available for collateral. Had strong damages that we can get up to 25. And in fact, although this slide doesn't show it, my guess is that of the 56 claims that maxed out, we probably also got into that additional 10,000. But so long and short, if we were to raise our cap, that would require statutory change. I don't know that we're there. I've had a lot of conversations looking at the data because, we have the conversations about, well, we need to raise our funeral burial. That's an easy lift. First of all, it didn't require statutory change. I don't know. I don't know if we need to raise our cap to the levels of the surrounding states. I know Colorado is really sort of an outlier right there. Not only, first of all, they have a decentralized system. So instead of just one of me, there's 30 jurisdictions or 20 jurisdictions that have, they're each individual and so they manage those. And so in addition to having twice the amount of money available, they also make their claims available for a lifetime, which is impressive and appealing. And I hate to be the bureaucrat in the room. I don't know how Wyoming would manage that. I have one claims analyst. We average about 600 claims a year. And with the 24-month cycle, so we have easily 12,000 to 2,400. I am struggling with numbers, so I don't do math. 1,200 to 2,400 rotating files as it is. And I think that it is admirable that Colorado's able to do that. I don't know how we're going to do that. But you know, there could be some thought given to raising our statutory.
Any other questions?
Thank you. My last few bits are, just to underscore how we kind of open this conversation, which is to say, when we're looking at overall public safety, please remember that the work that you're doing to reduce recidivism is actually also part of the request of victims. That most of the victims I've ever worked with in my entire life started in the 90s. Maybe I don't pass that old, but the piece that's important to remember is that almost every victim I worked with just wanted the behavior to stop and just wanted to make sure that no one was ever harmed again. And so when you're looking at the overall Justice Reinvestment package, when you're looking at public safety more broadly, anything that reduces recidivism, anything that decreases the chance that someone will harm someone else is also done at the request of these people that are reporting crimes, experiencing crimes, and having longer term trauma effects. So I appreciate your time today and look forward to more continued conversations.
Okay. Thank you, ladies. Mr. Pelka.
Thank you. I really appreciated the chance to hear that, and I was thinking about some connections between the previous section and this section. The previous section covered some increases in arrests, case filings, and prison admissions for some violent crimes, including aggravated assaults. And I think about aggravated assault rates, I'm thinking about about the victims who sought, victims who experienced violence, experienced crime, seeking reimbursement or benefits from the compensation program to address some of the ramifications from that crime, including medical, mental, and other mental health counseling. When I heard Grace and Carol talking about both assistance and the reach of the programs, I thought about a theme I've heard from this committee since I first appeared in front of you, which is the challenges resulting from being a large geographic state and having many rural and frontier areas, many service providers trying to reach large sections of the state, confronting lack of program providers in particular areas, as well as lack of program providers serving specific victims and their needs. And that's why I was so struck by Kara's decision to carry out a need assessment, which is using available information from your Statistical Analysis Center and from other resources to look at the needs of victims in all counties across Wyoming and all parts of the state to better support and develop programs serving victims in all parts of the state. And then finally, on the topic of restitution, I thought a lot about the title of the first section, which is improving accountability for people with nonviolent offenses. And what I heard Grace and Kara underscoring is the role of the criminal justice system in providing effective and meaningful accountability for people who are in the system. And restitution is one way for people to demonstrate taking responsibility for the consequences of their actions. I mentioned people with property offenses because in another state where there's more restitution data, we looked at the types of offenses and the restitution orders that are attached to them. And in that state, 4/5 of sentences that had restitution orders involved nonviolent offenses, which makes me think about victims who were not eligible for victim compensation benefits because those primarily serve victims of violent and sex offenses. So those victims may have had nowhere else to turn to receive compensation for their financial losses than through restitution. And I think about so much of the following sections we'll have today will look at what meaningful supervision looks like. And we know that people who are on supervision are able to maintain employment in the community, and they're more likely to have the funds available to make not only the number of restitution payments, but the quantity of restitution amount owed during that time period. And probation and parole can be a way for people to earn a living and take responsibility for their actions. So the idea of helping the system be provide better communication can actually help more victims receive restitution, because if everyone does his or her job a little bit more in a more focused manner, you will see more restitution collected. So appreciate the chance to kind of share that reflection. I really appreciate hearing from them. The chairs of the committee, I do see in the agenda we have time for agency responses, and then a lunch on there as well. I will defer to, of course, as your presenter, to the chairs on whether they would like to stick with the approach. We're also ready to cover the following section whenever the time is right. But we stand ready, the chairs, however we'd like to proceed.
Okay, let's proceed to Dr. Lampert and Ms. Chambers, if they have any agency response. I think we'd have time to hear from them and the public as well before lunch. Director Lampert?
Mr. Chairman, members of the committee, Bob Lampert, Director of the Department of Corrections. I'll reserve most of my comments for later in the day simply because most of the comments are directed at later sections, but I did want to comment on these first three sections. First of all, the data supports what I'm saying for the past 15 years or so, that we don't see some change in public policy, not only going to fill the prisons, which we already have, but we're going to outpace the availability of the prison beds that we have. Let's see. So the choices are to spend more money for incarceration or figure out ways to spend that same amount of money earlier in the system to keep people from coming to incarceration. So in terms of the overview and introduction, part of the comments is basically in order to reduce recidivism and to decrease the number of people coming to prison, we're going to have to come up with ways that, as the judges indicated, provide treatment, increased treatment accessibility at the community level, and where it's more effective, according to the data. We agree that shifting attention to the front end of the spectrum is necessary, and that by increasing access and services in a way that not only holds offenders accountable, but also holds vendors accountable for delivery of services that are best practice and in compliance with best practice approaches necessary. We agree that we should invest in more in community programs and less in incarceration if we can. In terms of recommendation about looking at sentencing data, I'm a firm believer in data. It's what's helped us adjust our internal policies to be one of the most effective correctional systems in the nation. Proud of that. But we do know that there's some gaps in that data. One of the gaps that I think could help courts as well as ourselves is looking at outcome data for each of the potential or each of the different sentencing options that's out there, whether that's ISP or probation, traditional probation, whether that's boot camp placement or incarceration, providing more detailed data to the courts that might inform those sentencing options. We do try to provide that information, usually annually to the judges, but it's kind of a broad brush look. It's not broken out by region, etc. So a more robust dive into the available data, I think, would be useful and certainly should be supported. In terms of connecting the crime victims, all the recommendations and discussion that were provided during that overview, we agree with. Let me look real quick. One thing that I don't think was really clear is around the AOAA data. I think what the real suggestion is or should be is that we develop data around what reasons are leading to not accepting diversion under AOAA, and having the data to say these are the reasons, this is how many people aren't being placed on, that are eligible under AOAA, aren't being placed on probation and referred for treatment at the community level, so that we know what those reasons are, better informed policy decisions about how we can close those gaps as well. So I don't think it was necessarily a suggestion that provide more guidance. I think it's more of a suggestion that we look at what options are currently being used and have the data to support those options. So I think that's another area where we need to place more emphasis on data collection. I'll reserve my other comments for the other sections.
Thank you, Mr. Chairman. Representative Pelka. Thank you, Mr. Chairman. I just want a quick update on prison populations. I know from experience that, some of my clients are being shipped out of state because we're overcrowded at this point. So what are those numbers where we're sending inmates out of state? What are the costs associated with that? And what kind of pressures are we having right now on our facilities?
Mr. Chairman, Representative Pelkey, as was pointed out by Mr. Pelka, we're basically at capacity, specifically because we had to reduce the number of beds available at WSP. We have 88 inmates currently, well, actually 94 inmates currently out of state in Mississippi. Rental beds, another 64 or so in rental beds in county jails. Those inmates were displaced in part because of need flexibility to shift inmates within WSP as we do repairs there, one housing unit to another. Part of it is also a result of increasing numbers coming into the system, projected to increase our population by the year 2020 by another 146, I think. And by 2023, that number's right at 200. So those are additional people beyond what we currently have. So this entire effort is to say, is there other options other than spending $51 million to operate the way that we've been doing in the past?
Representative Pelkey. I wanted to touch on the cost comparison of what are we spending per inmate per year in Mississippi, and how does that compare with what we're spending here in Wyoming?
Mr. Chairman, just looking at the raw numbers, it costs about roughly $75 a day to house somebody out of state, about $65 a day to house somebody in rental beds in state, compared to about in the neighborhood of $130 a day at Japan. However, that's just the cost of, just look at the cost per day. What it doesn't take into account is for every inmate that we send out of state or into a jail bed, we're still operating a full prison facility. So we have those $130 a day for operating the current facility plus costs of sending somebody into a rental bed. The only offset against that is marginal cost. How much does it cost to feed somebody in a day? How much does it cost for clothing and laundry? How much does it cost for compensation for the work that they do, et cetera? So it's more than maybe a $15 to $20 a day reduction below the combined cost of in-state and out-of-state placement.
Representative. Just out of curiosity, is it a public or private prison in Mississippi?
Mr. Chairman, it's privately operated. Thank you.
Representative Stitt.
Mr. Chairman, Director Lampert, I think that many of us are broadly supportive of putting more resources into drug treatment for probation and parole. Question I've got about the Department of Corrections policy, you perform an assessment to determine someone's level of need. Is the same service provider allowed to both perform the assessment of what someone needs as that also provides the same services?
Mr. Chairman, inside prison, the assessments are, well, first of all, the assessments are done by Department of Corrections staff, DSI level. So those are Addicted Offender Accountability Act personnel that are employees of the Department of Corrections or contracted to do that assessment. So that's the assessment that courts have available to them, making sentencing decisions and the initial guidelines that we have for placement and treatment once they are received at the Department of Corrections. Then the individual vendors may or may not accept that their indicator of what level of treatment to put somebody in. So generally speaking, if they don't accept the AOA assessment, or if they've been in prison for a while, we need to reassess them prior to placement. In most cases, the person that delivers the training is doing the assessment. That answer your question?
So, Mr. Chairman, some of the answer yes, especially on the contract basis. If you contracted out to say Southwest Counseling in Rock Springs, they might be allowed to go through the assessment and provide you.
Mr. Chairman, they have an initial assessment from the AOAA program, but whether or not they accept that may depend on how long ago the assessment was. So, I don't remember off the top of my head, but it may be a 6-month window or so that it's considered a valid assessment. So if it's been more than that period of time since they had that AOA assessment, then they're probably going to require a new assessment. Generally speaking, that's done either by their own staff or under contract assessment.
Senator Medica?
Thank you, Mr. Chairman. Is the Department of Corrections housing any out-of-state inmates right now?
Mr. Chairman, we house inmates on an exchange basis, 1-for-1, out of, through the interstate compact. But that means for every one that we basically have in state, we've sent somebody to an out-of-state placement because they can't safely live in our own system or because their family connections, et cetera, are in another state.
Thank you.
Any other questions for Director Lampert?
Thank you, Mr. Chairman.
Okay, thank you, Director. Ms. Chambers, did you have any additional ground to cover? Okay. Very well. We'll move to a time of public comment regarding what we've heard this morning. So would anybody like to get some feedback about all those things that are going through their mind as they read the reports? This is some of the other discussion. Mr. Trent.
My name is Peggy Trent, and I'm an Albany County prosecuting attorney. And I just wanted to highlight some of the information you received this morning. For my statistics, is completely accurate. When I first took office in 2015, at that time, there was no case management system in place. I was able to implement an updated system in June of 2015. My statistics from 14 to the present, we've seen a 65% increase in drug cases. I believe the slide indicated 83% increase from 2013 to the present, so, or I think to 17. So I want to let you know those statistics seem and appear to me to be accurate in what we've seen. So the question becomes, where are we seeing the breakdown? I believe, Mr. Chairman, you had indicated, are the prosecutors being in our culture over-aggressive, law enforcement, not over-aggressive, I think you're trying to say, are we enforcing more of the laws and not exercising our discretion? The average, I wrote an email to Steve Woodson of DCI in March 26, 2018, with an analysis color-coded chart breaking down our drugs. Our system that I use for case management antiquated, so I had to literally go hand by hand. So let's say, for instance, an individual is charged on a 5-count felony indictment. They may have a charge for pot, marijuana, opioids, or we would see meth. In my experience, I'm seeing an increase in meth and opioids. I will tell you with the marijuana, just to give you an idea, in 16 and 17, and this is from the email that I provided Mr. Woodson and my local sheriff and other law enforcement, we were seeing, I said, an average of 12 pounds of marijuana in these stops. We had stops by Highway Patrol and Sheriff's Office, and this would be mostly the corridor from 287 to 80. We would see approximately, and let me give you the numbers, this is amazing, 19.34 pounds of marijuana, a stop involving 292 pounds of marijuana, another of 112 pounds of marijuana, 102 pounds of marijuana, 42 pounds of marijuana, 10.26 pounds of marijuana. And let's not forget meth. We had a lot of those stops involving high quantities of meth. Another 22 pounds of marijuana, 47 pounds of marijuana. Then I get into 23 pounds of meth coming through. We have 9 pounds of marijuana, another 15 pounds, another 27 pounds of marijuana, and another stop of 27.5 pounds of marijuana. These are high quantities of marijuana that is coming through our corridor, and that's just Albany County. That's not including Sweetwater County, Carbon County, which we have Judge Danessa Snyder here today, as well as into Laramie County. We have, the highlight of today's presentation is on state funds and what you're incurring. At no point does this presentation include the costs we're incurring as counties for prosecution, for defense attorneys, and for the cost of the jails and housing and what we're seeing an increase. There has to be some type of reform as we get into pretrial release programs. Right now, our judges are attempting to try and adjust the overcrowding in our jails by releasing people, which then low bonds, resulting in us having no shows for court, failure to appears, then we're incurring more costs to bring them back for these high-level crimes. I have been very aggressive in going after revocation of bonds with the Supreme Court right now. We have been successful in getting those monies from bondsmen and others where we have money, but that goes to your state, thank you, education system when those monies come in, but not to the cost that we're incurring of staff time and prosecution. In my jurisdiction, I'm being accused of being over-aggressive with pot and being this, and I submit to you, what options do I have but to enforce the laws that are on the book? Yes, there are a lot in our community where we have enhanced felonies, where you have 3 convictions of possession and then it's a felony with no look-back limitation. There's various crimes that we can look to for reform and changing, but I'm submitting to you today that this doesn't even touch the costs we're expending right now. One of the things I do see that needs to be considered when it comes to drug treatment and our drug treatment programs is that it's voluntary. Voluntary, so you have to voluntarily agree to go into these drug treatment programs. So I'm not able to divert them unless they voluntarily agree or the court sentencing them into these drug treatment programs. You know, from a cost standpoint, I think I saw a slide that we spend $3,200 a year or a month for inmates in prison. That's what we're spending. It's $5, I think around $5.75 a day for probation. For drug treatment, I think I saw, and I may be incorrect on these, I think it's like $27, $35 a day. To me, from a financial standpoint, this makes sense from whether we can put them in a program. One thing I will say with pretrial release program, which we do not have right now, where probation parole is overseeing, and we see this in other states, there's no ankle monitors being utilized, no one overseeing. And what I submit to you is I have implemented these processes in the juvenile criminal system, and we are saving the state money on a monthly basis. And so there's a disconnect between what we're doing with adults and what we do with juveniles. We've been phenomenal moving in that direction with juveniles, but we forgot about the adults and how they handle it. So thank you.
Thank you. Questions from Ms. Penn?
Mr. Chairman.
I'll go with Representative Weckerly.
Thank you, Mr. Chairman. Thank you so much for your testimony. It sure shines a lot of light, and it is extraordinary as you talk about the high amounts of audit that is coming through in these corridors. Have you seen a corresponding increase in low-level possession as well? And what kind of increases have you seen there?
I have not broken, Mr. Chairman, I apologize, I have not broken down the numbers in my statistics. I can tell you, I'm the university town, and we are used to seeing, unfortunately, marijuana. We have seen a decrease in alcohol. Now the new drug is marijuana. I don't view it as being that we've seen any, I think it's always been constant here in our community, and maybe Sheriff O'Malley would counter. I don't think we're seeing anything more or less. It's always been there. It's how we approach it. We've been putting those cases for the university, mostly been going through our municipal court and not through our circuit court. That gives more flexibility to, I think, expungements and anything along the line for our young people. I think that I have reached out to student affairs here at the university with an attempt to start a diversion program. I have no funding for a diversion program for these low level pot cases where they're less than 3 ounces. So those, but as to our university students, it's usually the recidivism. We see the same people coming through, doing drugs, and family members, and we see it in our community, but also people passing through the transients.
Thank you, Mr. Chairman. Just a quick follow-up. So part of the reason I asked that question is because there is a narrative out there that we are throwing kids in this climber for full low-level pot possession. Based on what you just said, it doesn't sound like that is actually the case. Would that be a fair assessment?
Mr. Chairman, I would agree that we are throwing children in jail for low-level marijuana, not all the time. And let me tell you why. We have no pre-trial release program. So what happens is they get locked up in jail, misdemeanor cases, through municipal court, and they're being handled. I do not have the data to support that. I can just surmise this is what's going on, and we need pre-trial release programs that we can release kids out. We want to keep youth here, but if we're not a friendly community in how we treat young people, how can we expect our young people to stay in our community? That's why how we treat juveniles, how we treat our young people at the university is important. But I don't want you to think, I don't believe they shouldn't be accountable. It just means we need to think differently in how we're approaching it. Not to lecture, but these kids, their frontal lobes aren't formed until they're 25. And we're expecting them, they make poor choices, and we need opportunities to redirect them. And I think the university does a phenomenal job in intervening through our student affairs, but we need to do more in response through our criminal justice system.
Senator King.
Thank you. County Attorney or Prosecutor Trent?
I'm both.
Okay. I would urge you to get from staff a copy of a bill that we'll be considering tomorrow at 10:45 a.m. under judicial updates under the topic pretrial release. It's bill draft alternative penalties and pretrial release for alcohol offenses, and actually it's for any offense where alcohol or drug is involved. It, as I understand it, removes you have to agree to monitoring, and the judge has the option of saying you are going to go now on to monitoring. I've given it to each of these judges. I think we may lose them tomorrow, but they might have an opportunity to comment this afternoon. But I'd appreciate it if you take a look at that bill and you'd be prepared to give some feedback tomorrow if you can join us, or perhaps later today. The key, of course, is this is one tool that we've got to have funding for the treatment programs, obviously, but this allows immediate enforced sobriety right upon release after arrest. Thank you, Mr. Chairman.
Mr. Kochek.
Thank you, Mr. Chairman. Mr. Trent, it sounds like it would be critical of prosecutors or law enforcement. That was certainly not my intent. It was much more about local flexibility and your priorities, not about
Thank you.
Any other questions? Thank you, Mr. Trent. Someone else? Sheriff O'Malley?
Yes, Mr. Chairman, if I can just go off a little bit on what answer kind of questions that she and have seen a relatively dramatic increase in low-level marijuana possession cases, less to have an extremely professional and proactive staff of field deputies that are on 287 and I-80. 287 and I-80 all the time. Quite frankly, I'm not trying to be glib, but we've spent thousands of dollars on canines that are out to detect marijuana and other drugs, and the potency of the marijuana. Now you don't need a dog. They roll down the window and you can smell the raw marijuana in the car, the van, and that type of thing. And we're on 287 all the time because it's really starting to be traveled much more than it ever has been in the past. And it wasn't too long ago when my deputy stopped a young man, and when they rolled down the windows, it was like a Cheech and Chong movie, and the smoke came rolling out. And the deputy asked the driver, he says, you know, on a scale of 1 to 10, how big are you? And he said, I would do it at least an 8. And they stopped him for doing 97 and a 65. So, you know, they're out there a lot, but what I wanted to get back to was putting these people in jail, and it's not occurring at the level that it used to. We stop people with minor amounts, but Highway Patrol is doing the same. There is discretion on whether we incarcerate, arrest, and incarcerate or not. And many of my deputies are now writing a citation, releasing the people, seizing the drugs, releasing them to go on their way. And what that results in is about 8 out of the 10 warrants that I sign every week are for FTA misdemeanor marijuana. So, and going on a little bit beyond that, the opioid issue. In my first 30 years of law enforcement, I saw heroin twice. Once in the wallet of a guy coming through from New York, and once in the arm of a young man who allowed his friends to shoot him up and he died. Now we see it all the time. We've had many opioid-related deaths in Albany County in the last few years. And for a while anyway, those cases were running out in front of methamphetamine cases. Now it's dropped back. One of my deputies stopped a car the other night at heroin, meth, cocaine, and marijuana. 4 people in the car, 4 different drugs. And it is definitely an issue for us.
Thanks, Mr. Sheriff O'Malley. Thank you, sir. Mr. Odenkirk.
Thank you, Mr. Chairman. I thought I'd hobble back to the back so I wouldn't interfere so much approaching the front and reflect for a moment with Mr. Pelka on a couple of key points. Byron Odenkirk, representing the Wyoming Association of Sheriffs and Chiefs of Police. Let me pick up on a couple of quick comments, if I may. I'm very encouraged at the first 2 sections and look forward to the next couple of sections because it reinforced our earlier discussion of early age intervention, early intervention into the criminal system so that folks didn't end up in jail. The statistics and the data mining that have been done so far reinforce that. And I think, in the words of Judge Grant, was correct to say that you have to work really hard to go to the state pen. You've exhausted lots of options. But part of what this report points out is there aren't very many options at the front end to deal with it. So I am encouraged by that we may have a meaningful discussion of options on the front end. We've discussed for years budget cuts. I remember bills talking about doing less with probation and parole, having less people on probation. When this report indicates that we may actually want more people on probation, more people having those services so that they don't end up with that bed. The other thing that the report at this point so far points out is it's not your first offense that lands you in jail. It's that multiple appearance before the judiciary that at some point leads to you ending up in the state pen based on an exhaustion of the services rendered so far. I would offer that at some point I'm encouraged that we'll have a discussion of those services and what we may want to invest our justice dollars in to help, again, to avoid them going to jail. I do want to point out a correction, and I've already visited with Mr. Pelka on a correction of a correlation between 2 slides that paint a very different picture, if you will, and I think it is, the first one is slide 6, I'm wrong. Slide 24, if you would. Page 24, and this is Pelka pointed out, you note that in 2017, drug offenses went up for state admissions and commitment for nonviolent offenses. So they flip back to one more by 3%. Yet we had 46% increase in the crime of possession. It ultimately resulted in 3% increase in admissions to the state pen. The correlation that happens that is incorrect is just before the conclusion of section 1 on slide 31, which Mr. Pelka assures will be corrected. Line 2 of the last bullet points out that new court commitments to prison for drug offenses increased 46%. That will actually, I believe, in the final version, will read 3%, not 46%. Because the 46% is the increase in possession charges, but not all 46% of those resulted in admissions to jail. So again, it reinforces what our county attorney for Albany County, as well as the sheriff said, lots of alternatives exist now for dealing with simple possession. It's those bigger possession, manufacturing, delivery folks that are resulting in going to jail, not the mere simple possession. With that, Mr. Chairman, I'll save further comments for when we get through other sections.
Okay. Any questions or Representative Wiggers?
Thank you, Mr. Chairman. Mr. Weckerly, do you have any statistics to show what percentage of people are actually Wyoming residents versus individuals from other states who may be using us as a court order regarding these possessions?
Mr. Chairman, I do not. And I'm unaware of any report that we submit via the arrest data or the county jail data to the state, which would lend itself easy to be able to obtain it. If at the conclusion of this, and I'm hoping that we do, and or voice some support to Mr. Pelka, that we do some further data mining at the local level to help answer some of these questions, given the fact that Wyoming is a very small state, our numbers are relatively small in the greater scheme of things. Data analysis time would be less than, say, a large state with large issues. Some of the data mining may prove useful in this area. I'm reminded that sex offenders, for example, it used to be that over 64%, I believe was the number we used several years ago, of sex offenders on accounted in Wyoming were from out of state with zero ties to Wyoming. I don't know if those kinds of numbers would hold for that larger possession, kinds of delivery, kinds of manufacturing. Anecdotally, I see Colonel Howard here, who in his former life was the deputy director for the Division of Criminal Investigation. And I would offer from a task force perspective, I'm pretty sure he would offer that most of those drug rings and some of those folks are certainly from out of state, taking advantage of folks in Wyoming. But I'm not too sure either one of us would be able to clearly come up with a number this morning.
Representative Pelka.
And speaking anecdotally, and as an attorney who often defends those cases, I would say particularly the large amounts are from out of state, and they're also in transit. They have no intention of stopping and selling in Hollands or doing anything like that. They're just largely mules. The smaller ones tend to be local cases, though we still have a lot passing through those to get busted on the highway for them. By the way, one note, I know the last name resonates really well with you, Pelka, but his name is Mr. Pelka.
Appreciate it, Mr. Chair. Any other questions from Ms. Protocol? All right, thank you. Someone else from the middle of a time of public comment, Colonel Howard.
Morning, Mr. Chair. Kevin Heller with the Wyoming Highway Patrol Colonel. After having heard the Highway Patrol mentioned several times, I felt compelled to come before the committee. I wanted to point out one thing, and that is I kept hearing the year 2015 as sort of an increase whenever interdiction were starting to perhaps be identified on a more frequent basis. From my perspective, I agree with that. I think in part, some of that is due to the highway patrol's increased enforcement efforts in this area. That is not to be inferred as that those efforts were not being adhered to prior, but there certainly was an increased focus of criminal violations, further criminal activity being identified on our corridors and our local highways throughout the state. Having said that, we have seen, certainly seen an increase in haul trucks, not the least of which is marijuana, both in smaller quantities and larger quantities. And, you know, being as state troopers, my folks work throughout the state of Wyoming in 23 different jurisdictions. So we very much work in line with our prosecuting attorneys and our local partners at the sheriff's office and police departments. And having said that, there is a variety of charges that may come from these larger interdictions. Whenever I see it noted possession, I can tell you that it is not infrequent that there will be large quantities, meaning several hundreds of pounds of marijuana. And perhaps the initial charge is, or the initial thought of the charge is possession with intent to distribute. And from my perspective, it's not uncommon for that to be reduced to simple possession, felony possession. So I wanted to come before you today to represent that the Highway Patrol intends to fully enforce the current laws. And this goes beyond just drug interdictions, but all interdictions. We also have human trafficking and many other things that are occurring in and throughout our state. And so we are very aware of that. But in addition, there's I think an extreme amount of oversight and discretion that is being considered as a part of charges and plea bargaining that is occurring with our prosecutors that do end up going before our judicial system.
Questions for the Colonel? Someone else wish to speak? Judiciary, any feedback on the feedback? Good for now?
Chairman Marc, Tyler, I don't know.
Okay, thank you. Mr. Pelka?
One of the highlights of this project so far, Marc again, is getting a chance to get to know Byron. And I, given sort of the anxiety from the room, I would probably mispronounce his name if I tried to. So I take absolutely no offense at being called, especially if I'm being compared in the same light as the representative of the committee. But please call me Marc. Mr. Chairman, I saw that there's a kind of a lunch break, well-deserved lunch break for folks listed on the agenda at noon, which is only about 20 minutes. I don't think we can get through the next section by then, so I wanted to notify the chairs of that fact and defer to you and your judgment on whether you'd like us to begin the section to get as far as we can before the break, or if you'd like to perhaps break early and reconvene after. We are at your disposal, sir. Please disposal.
I would propose we break at 11:45, but come back at 1:15, so we'll still take the hour and a half break, and we will reconvene at 1:15. Tori, anything in terms of housekeeping we should know?
I don't believe so, Chairman.
Will it be safe for us to use computers and the like?
Yep.
Okay. We have enough law enforcement here, you hope the computers.
Okay, let's take lunch break then until 1:15.